Hello, everyone, and welcome to the conference Privacy for International Business. We are starting today with the overview of today's agenda of the conference. My name is Siarhei Varankevich. I'm a founder of DPO Europe GmbH, which is a training and consulting company working in the area of data privacy. We are official CIPP training provider. So we train people for CIPP and CIPM certifications. We also consult companies and help them to mitigate privacy risks when working with personal data of inside the European Union and outside the European Union. So we work in multiple jurisdictions, and a special focus of our company is European Union, of course, but we also work with Asian and Middle East legislations like recent GDPR in Saudi Arabia and United Arab Emirates. So let's go on to the conference and current agenda. In the landing page that we published before the conference, we claimed that you would receive the plan for compliance with the GDPR. And indeed, we work on certain framework. This is a short version of this framework, which is called 33 steps for compliance with the GDPR. And we distributed the presentations along with the key points of this framework. But let me first start with the overall this flow chart. Before I start with it, I must say that we make certain processes and processing of personal data compliant with the regulations and laws. We cannot make the company we don't make companies compliant because the GDPR and other privacy laws speak about making data processing operations compliant with those laws. So basically, when you do this exercise of following the law, you would need to put every single data processing activity through this flow chart in order to establish certain rules and make changes inside your business processes. So the first and most important step is identification of personal data, is finding and mapping your personal data in the system. And usually this exercise is called ROPA, Register of Processing Activities. So we make this inventory of personal data. We also follow its flow. So we create data flow mappings. And when making this exercise, we must define which of the data inside the systems are personal, which data is anonymous, and what personal information could be classified as pseudonymous. And on this stage, we need to find this fine line and border between the anonymization and pseudonymization, because pseudonymization does not release you from GDPR duties, but anonymization does. So if you answer to the question, is the data personal? No. So if you say no to this question, then GDPR or other privacy laws don't apply to you, because those laws are created to regulate the relations with the connection to personal data, personal information. So this is the basic trick, if you say, for avoiding these strict and burdensome privacy laws and requirements. So making your information anonymous would help you with cutting costs and of course, not only cost for your company, but also cutting risks for data subjects. So for this important area. We'll have the first presentation at this conference, and I'll be presenting the slides devoted to understanding the differences between anonymization and pseudonymization and aggregating data. After you defined whether information is personal or not, and if it's personal, you would need to follow the next steps, which are definition, which is determining whether GDPR or other privacy law is applicable to you. There are two levels of applicability. The first level is material scope of the applicability and territorial scope. Unfortunately, time constraints during this conference were not did not allow us to include more presentations and slides on the topics of material and territorial scope. But if you visit one of our courses, you would definitely get the full and detailed information on the applicability of the GDPR, on Article 3 of the regulation, on the guidance on territorial scope of the GDPR, and certain cases of European Court of Justice devoted to the material scope. Then the next step for compliance would be definition of your role and understanding your role, whether you are a data controller, joint data controller with someone, or you are a data processor, or maybe you are playing the role of the third party in this processing. You are some kind of recipient, but you do not play role in determining purposes and means of the processing, or you don't follow certain instructions by some other company. So you are just third party. And depending on your answer, you would end up either on the step 15, which is selecting proper lawful basis for your processing, or the steps starting from 27, when companies that are data processors have to help data controllers to assess risks and guarantee rights of data subjects, as long as make the processing confidential, keep information integrity and availability. So let's assume that you indeed determine the means and purposes of the processing. Then you would be responsible for following the principles of the Article 5 of the regulation. Those principles are pretty much the same along all current and modern laws in data protection. These principles are fair and transparent processing, along with lawful processing, purpose limitation, data minimization, keeping data accurate, and limiting its storage. To the most tricky steps of this compliance process, we invited Tatiana Sivucha with great experience as a data privacy counsel in technological startups to show us a magic matrix and use cases for implementing data minimization and purpose limitation principles. Those principles are hard to follow, and a lot of work should be done to comply with these requirements, but probably you would get the understanding of prioritization and certain tools that would help you to focus on the most important processing operations and on the most important activities. And Tatiana will share her matrix, magic matrix, and we would distribute this matrix to the registered attendees of the conference. Then we have a number of presentations devoted to privacy by design, assessing the risks, and other process-related activities. So with the slides on building privacy into product design, we'll have Louis-Philippe Groton, who will share his practical experience of implementing privacy by design and Article 25 rules in the startups, in small and medium-sized IT businesses. So we will also meet Alina Voitukhovich, who is IP, IT, and privacy lawyer and certified information privacy professional. She will cover the topics of class actions, which are overshadowed by privacy fines inside the European Union, but might be even more risky for business acting worldwide, including the United States. And then we will have an express consultation, and unfortunately we were not able to follow this flow while building the program of this conference. So you need to check with the program at gdprday.com to check the time of this express consultation. But if your company is implementing AI and machine learning into their products and operations, you can ask questions and get consultation free of charge during this conference. It's express consultation. So Denis Sadovnikov, who has been working with AI and machine learning requirements for many years, would share his experience with you and would be able to answer some practical questions. Along with me, since I'm also a bit exposed to the topic, so we'll consult the companies or attendees of this conference later today. And since our conference is called Privacy for International Business, we have two topics, two presentations devoted to international data transfer mechanisms inside the European Union. So Denis Sadovnikov would present on how to legally transfer personal information from European Union. So he'll cover the rules and the notion of the cross-border data transfer and Chapter 5 of the GDPR. And we'll have a separate consultation with renowned speakers today. So if you have some questions devoted about the international data transfers, please don't hesitate to put those questions in the chat box in YouTube. We'll channel those questions to our speakers. And today we'll have Christopher Schmidt, Denis Sadovnikov, me as a panel for express consultation on navigating the complex landscape of international data transfers. So we have a quite large target group for this conference, and this target group is professionals who are looking for certification opportunities, and mostly we speak about two recognized certifications in data privacy, which are CIPP, Certified Information Privacy Professional Europe, and CIPM. So we invited recent exam takers of CIPP and CIPM to the panel, and they will share their experience of taking the exams, or on how they prepared, what are the benefits of the certifications. And also we invited not only speakers, but also a privacy expert who's teaching, who's delivering CIPP and CIPM training. So he could also guide us through this process of preparation for the exams. And finally, at the end of the conference, I will return to this diagram, to this flow chart, and we'll make a summary of the action plans that we got during this conference. And this action plan would include the major points that we heard from all speakers during this conference. So let's go on with the first topic of today, which is understanding the narrow line, the narrow difference between anonymization, aggregation, and pseudonymization. And as I promised to my friends in LinkedIn, I'll present my own development, my own product, which is Formula of Personal Data, that would help you to simply answer to the question about whether information is personal or not, and would help you in explaining to your colleagues, to your co-workers, this quite complicated and complex notion of personal information. The slides that I'm showing now are part of my my own training. So I took them from this training. So some of you has already visited this data privacy professional training with me, and those slides would be familiar to you. But those who did not take part in the training, this information might be quite interesting, since we are breaking down this complex legalese concept of personal information into a formula, something that is easy to manipulate with, to work with, and so we operationalize this concept of personal data. And the first thing that we need to do with breaking down this definition of personal information is to define what is identification. So identification is actually a process when you make someone in the group distinguishable from other members of the group. So you couldn't identify anything and anyone, but in the context of personal data laws, we are speaking about distinguishing people. So on this graphic, you can see a person on the bottom. So he could be identified, he could be distinguished from the group by his tie. So this tie becomes a distinguisher or identifier for data subject. And when we break down all personal information about us, we can see two major layers surrounding us. The first, the nearest layer is layer of identifier, which is our full name, ID, DNA, or some other identifier, including online identifier or user ID inside your system, IT system. It doesn't even matter whether data subject knows his user ID or not. This user ID is used to distinguish him from other users of the website. So this is quite clear, and this list is not exhaustive. In Article 4 of the GDPR, you have just list of some examples of those identifiers. So more interesting for us is this additional information that is not used for identification, which is also a part of personal data. According to the Article 4 of the GDPR, the first paragraph of this article says that personal data is any information relating to data subject. So any information relating, so any information connected to identifier becomes personal information. And to limit this scope of this information, this outer layer, we have three criteria that make this relating information personal. The information should meet just one of those criteria to become personal. So when this additional information is actually part of content, describing a person, then it's personal data too. If the information is collected and used to create a result and influence data subjects, then this information is also personal along with the identifier. And when the information is not yet influencing a person, but may influence because it is collected for the purpose of influencing data subjects, then the information is also personal. And I broke down this concept of personal information into two major parts, which is data of identified individual and the data of identifiable individual. So you can see from this diagram that personal data could be broken down into these two major groups, and the most easy for us is the group of identified individual, where you have a full ID, then all information that is part of this ID and all information that is relating to the identifier through content, result, and purpose becomes personal information. So in mathematical terms, the personal data in this group could be expressed with the formula ID plus info equals to personal data. So when you have a full ID and you have additional information, like on the picture here on the right, this whole sentence becomes personal information. So a person on the picture has a house in Munich. Over here, you have ID, his face, and additional information that could not be used for identification, like house in Munich is too generic information for identifying individual, but it's also a part of personal information. And the most tricky for data privacy professionals part is determining the data of identifiable individuals, because we are speaking about possibility of identification, and possibility is hard to determine. And then those examples are modified. So on the picture here, let us move here. On the picture here, you can see a person who is masked, who does not does not show his full ID, his full face, but part of his face is hidden from your eyes, and it's harder than usual to identify him, but it's very possible. So in that case, the cost of identification, the efforts you need to identification of this person, of determining who is on the picture, is quite low, and benefit even the feeling of satisfaction that you got after this identification is higher than the cost, because cost, like, I don't know, maybe a quarter of a second, and benefit, this feeling that you was able to identify, to recognize this individual is higher. So in that case, we are expressing this information this group of personal information, of personal data, with a more complex formula where you don't have the full ID, you have a quasi identifier, semi-identifier, which is represented here with the expression ID -6. So -6, it's a hidden information, the information you are not showing that needs to be restored or recovered to get the full identifier. And so this is not for IDs, but in mathematics we show it with the formula ID -x. And then we also have this additional information that is related to data subject. So in that case, you have full formula ID -x plus info equals to personal data, but we have one important if. So if cost is less or equal to the benefit of someone, benefit of identification for someone who could get an access to personal information. It's very important if, because with this if, you depending on what you have in this inequality into this second expression, whether cost is lower or higher than the benefit of identification, the answer is different. For instance, if cost would be higher, for instance, if you have an individual with the mask like that, this information, the same formula would be equal to anonymous data if the cost is higher than the benefit. So the first output that we get from this part of my presentation is actually that the difference between the data of identifiable individual and which is personal data, and the data of individual who is unreasonably identifiable, which is anonymous, is this cost and benefit part of this formula. So while making information anonymous, you would need to consider the time, effort, and resources that actually represented in the formula by cost, and consider the effort, not only effort, but also the benefit for anyone who could get an access to the data. So let me draw a line. We'll try to use my stylus. So basically, if you have a certain context, a certain okay, let's try to yeah, it doesn't work today, so no problem. So in understanding the anonymous information and finding out whether information is anonymous, indeed, you would need to determine the context, the surrounding where the information is processed, and determine this and check whether the cost for identification of the individual is higher than benefit for every single controller, data recipient, processor, or third party in this context. So basically, you need to determine whether not only your company yourself does not have means and interest in re-identification, but also whether it's true for every single party involved in this data processing. The language of the GDPR is stricter than that. It says that you need to determine it for anyone. It doesn't mention any context or surrounding or processing as limits, as limits for this exercise. So if you follow the wording of the GDPR, you would need to do it for every company in the world and for any individual in the world. But the case law in the European Union and the guidelines from European from national supervisory authorities are shifting this definition, shifting this understanding to more narrow definition. So they speak about any individuals who could get an access to the information. You don't need to determine whether this information could be identifiable for everyone. You would need to determine only those parties that are involved in the processing. And recent ECJ rulings also say that you would need to, you may further limit this scope of analysis by limiting only to the parties that have a legal access to personal information. So you would not need to determine the identifiability for some hacker who might get the access to your anonymized data set. So probably hackers have much more reason for re-identification than your company, and but since this access was unlawful and you took reasonable actions to prevent this data leak, then you might exclude this consideration from your formula and determine that this information is anonymous because every data processor, every employee, every data recipient of this anonymized data set has no reason and is bound to process this information in an anonymous way. The employee, he or she is forbidden from re-identification. Your data processors have no means and also constrained by the data processing agreement. And in this way, you may treat this information as anonymous and avoid quite strict and heavy GDPR requirements by doing so. So, what is aggregation and aggregated data? So, aggregation and aggregated data is a way of anonymization information when you delete identifiers, when you create the situation when identifiers are not available, and from this large set of information, no one would be re-identified. But while doing this aggregation, we need to take into consideration the thing which is called differential privacy. So when aggregating information in one data set and then updating and adding more information into another data set, you are creating the situation when the newly added data subjects might be identified by comparing two data sets against each other. So to avoid that, you need to do hard and very high-level math to avoid and limit the chances of this re-identification. And only in that case, this aggregation would be deemed anonymization. But aggregation with the high likelihood of re-identification by comparing two data sets would not be considered as anonymization. And another thing which is part of my topic today is the difference between personal information, anonymous information, and on another side, on one side, and anonymous information. And fortunately, for many data subjects, anonymized information is considered to be personal. So basically, pseudonymous information is the personal information, and it should be treated as such. But since you are limited the risks for data subjects, you might go further with this information than usual. Legitimate interest is more likely for pseudonymous information. Information security measures could be less strict with regard to pseudonymous information. And what happens in the process of pseudonymization is actually could also be expressed with the formula of personal data, where you take this full and true ID of individual and substitute this ID with some pseudonym, and you take this pseudonym and keep it separately from this information, pseudonym plus real ID. So in that case, you would limit the risk, because if data breach happens to this pseudonymized information, then the risk for data subjects are lower. And if the table with pseudonym and real ID is leaked, then the risk is also lower, because no additional information is included into the leaked part of your database. So basically, the process of pseudonymization is the process of transforming ID plus info into ID minus 6 plus info, where cost is still less than the benefit for someone to identify the individuals. And the main party that would be doing the re-identification would be your company, because you are pseudonymizing information not to make it anonymous and useless, but rather to get the benefit from this information. So you keep the real ID somewhere else and would restore this link between ID minus 6, between pseudonym and a real true ID of some individual. So I'll check the questions in YouTube. So if you have the questions, please write them down, because the time for my presentation is over. Yeah, I don't see much questions with this part. And it's a good news, because probably most of you are aware of this difference, of this border between identifiable and unidentifiable individuals. So let me pause a bit for the next speaker and describe you what is gonna happen in the agenda in our presentation. So you could find the program of our conference at the website gdprday.com. Over there, you could see the program, and right after this presentation on the identifiability, we have the next topic, which is devoted to international data transfers. We jump a bit to the last the last part of this action plan. We jump to the topic of international data transfers, where we have to use proper mechanism for international data transfer, and this mechanism is described. Actually, the variants of this mechanism are described in Article 46 of the GDPR, or in Chapter 5 of the regulation, and we will. I will hand you over to Denis Sadovnikov, who is author of the dedicated course on international data transfer, who is Certified Information Privacy Professional Europe, and Certified Information Privacy Manager, and also has a fellow of information privacy. What is it? It's not a degree. It's yeah, not a certification, but rather kind of designation by IPP, which is International Association of Privacy Professionals. So I'll check with my technical team to check how many viewers are now in YouTube. So yeah, let me check it. Let me find our transmission. Denis, I'm aware that you needed to start like 8 minutes in 8 minutes. So maybe someone was planning to join you in 10 minutes. So we'll fill this time with some additional information, including technical information. Oh, one important piece of this information. Please like this transmission, press the like button, and more importantly, subscribe to the About Privacy channel in YouTube. In this YouTube channel, we publish our webinars. We are planning to transmit the conference devoted to the regulation on implementation of PDPL in United Arab Emirates as soon as this regulation is published. We plan a lot of webinars. Some of the webinars you could see on the channel. So please subscribe to our channel. It will help. It would help us, and we will help you also to keep updated. So let me check what are the numbers now. How many people are watching us? Oh, I see 10 more subscribers. Thank you, guys. Please hit the subscribe button. Okay, we have 314 individuals watching us, which is a great number and quite high turnover. Thank you for your attention. So please press the like button and subscribe button. And also don't forget that if you have some questions devoted to information, to data transfers, and implementation of AI and machine learning in your processes, you might get a free express consultation from Kristine Schmidt, from Denis Sadovnikov, from myself, and other professionals that would be part of the panels during those two blocks of our program. So, Denis, I hand over to you, so you can share your screen now. Yeah, we can see it now.
Can you see my screen?
Yeah, we can, and we can also hear you. Great.
Thank you, Sergey. And first of all, my warmest greetings from Belgrade, from the Serbian capital. It's nice, hot summer weather in Belgrade, and I hope that in the places where you are is the same. And you enjoy the summer and enjoy our conference. And going to the topic of international data transfer, I should first of all say that it's real topical issues, real topical issue of nowadays business practice, because most of innovative types of business actually need to transfer personal data from one jurisdiction, from one country to another, and even usually the more innovative and the more complicated is our business model, the more data transfers we should pursue. And I like the words of wise Elizabeth Denham. She said once that she stressed this point that our digital world is international and data flows around the world in a heartbeat. I open up my phone, check an app, and in a moment my data travels around the globe. Services like geolocation and cloud computing rely on international data flows. And regarding the point of cloud computing, actually, provider may even don't know where actually data are processed and stored, because the systems of cloud computing usually work in such a way that the servers which are more free and less busy at the same time may receive data, and data may be processed there just automatically. So all these things I mentioned just to stress the importance of the topic of international data transfer. But on the other hand, we can see that most jurisdictions around the world, including the European Union, including the GDPR data protection regime, establish some limitations for international data transfers. Why they do it? Why legislators impose such limitations? And if we open the GDPR on its first page, we can see that even the full name of this legal document includes the mention of two main purposes of the European data protection legislation. The first one is the protection of fundamental human rights, which is right to privacy is an important part of the set of fundamental human rights. And the second goal, the second purpose of the GDPR is the facilitation of transborder data flows, of free movement of personal data. And it seems from the first, at a glance, from the first sight, it may seem that there are controversy between these two purposes, between the purpose of protection of human rights, protection of right to privacy, and between the purpose of facilitation of free movement of data. But we should bear in mind that GDPR pursues the main idea of European integration. And the main idea of European integration is to create the single area of free movement of goods, services, etc., to create the single market, the internal European market. And we should bear in mind that when European legislators are talking about free movement of personal data, They mean the free movement of personal data within the borders of the European Union, of course. But on the other hand, when the GDPR was created, was drafted, the legislators had some concerns about the differences between European legal regime, which is genuinely based on the idea of fundamental human rights, and between maybe some other legal regimes, legal systems, jurisdictions around the world, which may protect fundamental rights, including right to privacy, less strictly, and maybe even imply some rules, some legislation which may be oppressive, which may allow state authorities to access personal data arbitrarily without proper guarantees of fundamental rights. That's why the European Union imposed some limitations on transborder data flows. And the main principles, the main principle of transborder data transfers from the European Union to third countries or international organization is included in their Article 44 of the GDPR, and this principle is that international data transfers from the European Union to the third parties, third countries or international organization shouldn't undermine the level of protection which is established by the European legislation. And these main principles, it's the main thing, the most important thing which we should understand and should bear in mind always when we are dealing with international data transfers from the European Union. Because as I already mentioned previously, the legal regime of international data transfers from the European Union may seem sophisticated, and it's not clear sometimes what's the right solution for business when we're dealing with international data transfers, and even is some operation considered as international data transfer or not. But if we bear in mind this main principle, that any data transfers shouldn't undermine the level of protection which is in place in the European Union, the things become more clear, much more clear. And actually, this principle is the useful, helpful, practical guidelines for any our operations with international data transfers. So the particular we will talk about this principle a bit more a bit later when we will discuss Schrems II decision or some further jurisprudence of the European Union, or first of all the Court of Justice of the European Union, because this principle explains the logic of the further decisions of the court, why European courts prohibit some data transfers, or on the other hand, in opposite, permit data transfers. So how GDPR and the European legal regime resolve this issue with the maintenance of the same level of protection. Actually, there are three main ways to transfer personal data abroad from the European Union. And also, I should point it out that when we are talking about the transfer of the personal data outside the European Union, the transborder transfers of personal data, we are also talking about personal data transfer from the countries of the European Union to the countries which are not member states of the European Union. If we are transferring personal data between two member states or two member states of the European Economic Area, it's not international personal data transfer at all, because it's a single market, it's internal market, it's completely covered the principles of the free movement of personal data within the European Union. And we should also add here three countries of the European Economic Area, which are not members of the European Union. It's just green light. Yes, it's just the main road, the transfer to another member states from one member state to another member state. It's just should be pursued without any restrictions, any limitations, and any additional instruments in place.
Denis, we just have like I got a question in
oh, perfect.
Yes. About this notion of international data transfers. So the question relates whether the data transfer outside the European Union is also considered to be a cross-border data transfer, because technically data does not transfer the external border of the European Union, but people collecting data, companies collecting data, for instance, from data subjects inside the European Union, whether they have to follow requirements of the Chapter 5 of the GDPR.
That's a very good question. It's perfect question, actually, and we should answer this question from the point of definition of international data transfer. And GDPR itself doesn't define the international data transfer, but the European Data Protection Board adopted recently guidelines about the interplay between Article 3 of the GDPR, which is about territorial scope of the GDPR, and Chapter 5 of the GDPR, which actually defines the legal regime of international data transfers. And the EDPB laid down three criteria of international data transfers. And all these three criteria should be considered cumulatively. They have cumulative effect. It means that we have international data transfer only if all three criteria are simultaneously satisfied. The first criteria is the controller processor is subject of the GDPR. It's the first. The second one is the controller processor who transfers the data, or exporter. Such controller or processor is called exporter. Disclose personal data to importer, and this importer is not in the European Union or the European Economic Area. It should be pointed out and stressed particularly that it doesn't matter that the importer is the subject of the GDPR in accordance with the Article 3. It also matters that this importer is outside the European Economic Area.
So basically, if your American website that transfers data to some, for instance, web application that is used for analytical purposes, and you're collecting data from European Union, from data subjects within the European Union, are the subject to the GDPR because of the Article 3, you are offering goods and services to data subjects that are based in European Union. So you are you have to follow the GDPR rules. So the first condition is met.
Is satisfied, yes.
Yeah. The second condition is that data is transferred to someone outside the European Union, correct? Or what is the second condition?
The second condition is that it should be two separate entities, two separate
so this
controllers or processors, yes. And in your example, the American company receives data directly from data subjects who are in the European Union. It means that Article 3 is applicable, GDPR is applicable, but there is no international data transfer because company receives data directly from data subjects, and there is no two entities, exporter and importer.
Yeah, and so it's international data collection, not data transfer.
Yes, not transfer. Yes,
from data subject to your company, right? But
yes.
After you transmit the data to some web app, for instance, also in the United States, then the second condition is
yes,
met,
yes.
Right?
If in your example, just imagine that this American company who collects personal data directly from their data subjects within the European Union, then decides to disclose these personal data to its contractor in the United States, and this contractor is in the United States, and it doesn't matter that this contractor is subject to GDPR. If this company who is the subject to GDPR discloses personal data to another company who is in the United States, it means that we have international data transfer from the European Union. It's not easy point. It should be, because in the first criteria, the EDPB pursues one approach. The approach of application of the GDPR doesn't matter where a controller processor is located.
So territorial scope Article 3,
yes,
right?
Yes, exactly.
We switch to the Chapter 5.
Yes, exactly. But in the third criteria, they adopt another approach. They adopt the approach of the location of the company. It's different because, as we all know, it's well known about the GDPR that GDPR applies extraterritorially in accordance with Article 3, Part 2 of the GDPR.
Okay, so to briefly, it's going to be international data transfer when data leaves data controller and travels to this web application in the United States. So basically, there were no international data transfer when the data was collected from data subject, but it appeared after the next transfer.
Yes, exactly. That's correct. I'm grateful to you for this question and to our attendant of our conference for this question, because it really clarifies the issue of the international data transfer. And also, I should add here that before this recent guidance of their EDPB, this point about the direct data collection, so-called international data collection directly from data subject, was a bit unclear, and there were different opinions and different practice in place about this point. But the International Commissioner's Office, the United Kingdom supervising authority in the field of personal data protection, clarified this point, but it wasn't done on the European level before this recent decision. Now it's absolutely clear that transborder data collection directly from data subjects is not covered by the rules on transborder data transfers, by the rules of Article 5 of Chapter 5 of the GDPR. So we can take one step back, and we already discussed the situation when we transfer personal data from one member state to another member state, and we said that it's not international data transfer at all. The second situation is a so-called adequacy decision. It's actually the first scenario which the GDPR provides us to transfer personal data abroad from the European Union. It's a so-called adequacy decision. It means that European Commission is entitled to decide that some third country or international organization has the same level of protection of data subject rights as it should be in accordance with European standards. Actually, that this third country or international organization provides the same or similar level of protection of data subject rights. In such case, if we have an adequacy decision, we can transfer personal data in the similar way, like we can transfer personal data to another member state. And there is an exhausted list of countries which are decided to be adequate, to provide adequate level of protection. And this list is available on the website of the European Commission, or may be found on the website on the EDPB, European Data Protection Board. But at a glance, it may seem absolutely clear, simple, that if we have adequacy decision, we can transfer personal data to this country, which is covered by the adequacy decision. But there are some nuances which are important, and which I should bring your attention to. The first one is that we have different types of adequacy decision. What does it mean? Adequacy decision may be full, partial, or sectoral. And also it may cover the whole territory of the country or only the part of the territory of the country. Most of the adequacy decisions which we now have, it's just about maybe 10 or 12 decisions. Not too much, not too many decisions. Most of decisions which already taken by the European Commission are decisions which cover the whole territory of the country and which cover all sectors of the economy. But the decision about Canada, for instance, is only for private companies. It means that we can transfer personal data to Canada only to the companies of the private sector and only for the purposes of the private sector. It means that if we need provide personal data to some state authority to Canada, it's not covered by the adequacy decision, and it should be done in accordance with other instruments, with other mechanisms, not adequacy decision. The second complicated example is the United Kingdom. The United Kingdom, the decision, the adequacy decision of the United Kingdom is not about only the private sector. It covers both private and public sectors, but it has some exclusion, some so-called immigration purposes or immigration rules exclusion. It's not easy in practice, but if we know that personal data which we are to transfer to the United Kingdom may be affected by the legislation or by the practice of this country regarding to application of its immigration legislation, it means that such transfer is prohibited, or at least we should use another mechanism, not adequacy decision. Also, we know that in the list of adequacy jurisdictions, we have some territories, some breached territories actually, but which have some separate legal system, some separate legal statutes, such as islands, Jersey, Guernsey, Man, Falkland Islands, etc. And also, we should bear in mind such details and take it into account. There are three main criteria for adequacy decision, and the sum of these three criteria should provide should ensure that the main principle of the international data transfers, which I already mentioned, about not undermining the level of protection, is in place. And the first criteria is the assessment of the whole legal system of the country, including the rule of law, including their practice of state authorities and law enforcement practices, and of course the human rights in this country. And it means that we are talking not about the declaration of human rights in the constitution, but on the real practice in this country. In which way human rights is are respected in this country. And the second criteria is important, and I think that it's the main obstacle for many countries to obtain the adequacy statutes. Existence and effective functioning of the independent supervising authority. And this criteria is also mentioned by the Article 15 of the Council of Europe Convention number 108. I mean, the modified version of the convention. And it means that actually the legal regime of the convention is very similar to the criteria of the Article 45 of the GDPR, and it's not occasionally. The convention, the modified version of convention, and the GDPR were developed, drafted, and developed simultaneously. And European legislators had the idea that if some country is complying with their convention, with the modified convention, it automatically provides the adequate level of protection. And in the third criteria of Article 45, the convention is also mentioned, and the participation in the convention 108 is also mentioned as an important factor for recognizing particular country as providing the adequate level of protection. So it's easy to check, do we have adequacy decision, what kind of adequacy decision, which sectors of economy it covers, and so on. But if we don't have the adequacy decision, we should go further to the second instrument, to the second regime of personal data transferring to a third country of international organization or international organization. It's
sorry for interrupting. We have a special surprise present to everyone who registered at the conference. We'll show the and we'll send to the emails the diagram, the flow chart explaining the whole logic of the Article 44, 49 of the GDPR. So the Chapter 5. And Denis and me, we are trainers of special dedicated course on international data transfer, and I might even show how it looks. So everyone who is registered at the conference would get this kind of flow chart. So basically, if we track where we are now with what part of Denis' speech we are now, we moved from the adequate country to the next step of adequate company. Adequate company is is the terminology that was invented by us, but actually this is the meaning of the Article 46 of the GDPR. I know, Denis, that you asked me to find this diagram before your speech. I found it. So if you would like, we could move on in explaining the diagram on my screen, if you prefer, or if you
yes.
if you're okay with using gdprtext.com, which is also our resource that contains GDPR articles with relevant recitals, guidelines, case law, and expert commentaries. You are free to use it instead of this diagram.
Yes, Sergey, thank you very much for sharing this scheme, and I think it's needed for our presentation. It will be very helpful for me as a speaker. And I ask you to share it further, and I'll explain the issues of transborder data transfers here. Because actually I bear in mind the text of GDPR, but it's useful for our audience to see some mind map before them. Yeah.
Yeah, this is our approach at all the courses by DPO Europe, GmbH, Data Privacy Office, and Data Privacy Group. We try to encode the complex legal rules and requirements, all those ifs and conditions into some kind of flow charts and show the logic. So basically, we checked whether it's inside European Union, whether it's the recipient is an adequate country, then adequate company, and probably it was going to show what are the ways of making company adequate.
Yes, actually, we have Article 46, which includes several instruments of so-called limited data transfer. If we are talking about adequate country, we can call it unlimited data transfer, actually. And if a country is not adequate, it means that the transfer is limited. To pursue the limited data transfer, we can rely on one of the instruments. And in practice, in vast majority of cases, it's SCC, standard contractual clauses. Because this instrument is available for any companies of any size, of actually any sector of economy. And the main points here that SCC, standard contractual clauses, are approved by the European Commission. It's just fixed clauses, fixed construction, which we can use. And they're available on the European Commission website and on the EDPB website, respectively. And it's prohibited to amend the text of SCC. We should use them as is. Because they approved, but we can use the particular set which is most appropriate for our particular situation. For instance, we have sets of SCC for data transfers from data controller to data processor, or from data controller to another controller. And the set, and depending of this, we should choose the appropriate set of SCC, and we should add the appropriate set of SCC to our core contract between the exporter and the importer. And this SCC constitute the integral part of the contract. We don't have too much time to talk about this, but what's important here? The most important thing that relying on SCC or even BCR or other instrument, it's not enough to transfer personal data lawfully. It's absolutely necessary, but not enough. What should we do additionally? We should do a so-called TIA, transfer impact assessment. We don't have this concept in the text of GDPR itself. The concept of TIA, transfer impact assessment, was invented by the EDPB, European Data Protection Board. In summer of 2021, the EDPB adopted so-called adequacy measures, the documents with long name, which usually referred as adequacy measures, or not adequacy, supplemental measures, as supplemental measures. It was done in the line of implementation of the European Court of Justice decision of Schrems 2. Because in the decision of Schrems, the European Court of Justice pointed out that it's up to the data exporter, up to the controller, to ensure that the instrument, such as SCC or other instrument for transborder data transfer, will be enforceable and will be valid in accordance with the legislation of the third country. Because, for instance, we are free to conclude contract, to conclude SCC, to include any guarantees in our contract, but it actually doesn't matter if the legislation or legal practice of the third country doesn't recognize such instruments, such rules as valid and doesn't enforce it in the courts or supervising authority. And what's the issue in Schrems? In Schrems, the main issue was that the United States of America have some legislation which provides the state authorities with the opportunity to access personal data without court order and without the appropriate remedies for people affected. And it was held to be compliant with the principles of the European legislation. And the court points out that it's always up to the data exporter to ensure that instruments which we use to transfer personal data will be valid and enforceable in this particular situation. The best example of it's maybe not the best, but my favorite example, which illustrates this issue, this problem, is the French decision of Conseil d'État, French Administrative Court, on the case of Dr. Leap, when Dr. Leap used AWC cloud solutions, which was provided by Amazon, but not exactly the same Amazon, but the European daughter company of Amazon, yeah. And it was pointed out in this case that due to the corporative connection, Amazon may have access to the personal data, and it means that being an American company, it may be subject to their order or to request of American authority. It means that American authority in such way may access personal data stored in service of AWC in Europe. Actually, court in this case agreed with this reasoning that it's possible, and we should consider the situation in similar way like personal data international transfer. But in this case, the court held that the measures of protection of personal data were sufficient to protect data from such access. It's very important.
So Denis, I think we have a time issue
yes.
here. So maybe to sum up the overall, like to answer the question that is a part of your of the topic of your presentation, how to legally transfer the data outside European Union. What would be the algorithm for making the transfer legal?
To sum up all which we discussed today, we should first say that we should always bear in mind the main principle, not to undermine the level of protection.
Yeah.
And always think about the data subjects and their rights, and not to pose the threats to these rights. The second one, we should the second point that we can transfer personal data within the territory of the European Union and European Economic Area without any limitations. And the third one is the same regime. Actually, we have transferring personal data to adequate countries, but we should check the type of the adequacy decision. Does it cover the particular sector of economy? Does it cover public sector or both public and private sector? And does it cover the whole territory of the country or not? And then we are going to so-called adequate company and to the instruments of Article 46, so-called limited transfer. And here we should not only rely on the given instruments, but we should provide transfer impact assessment and take all 6 steps which are prescribed by the UDPB decision of supplemental measures of protection. And actually, also, we should thinking about the additional risks posed by the third country's legal system, even in the case of adequacy decision, as the Court of Justice in the Schrems decision points out. Actually, it was adequacy decision which covered transfer personal data to the United States. But also we should bear in mind the mechanism and the nature of the legal system of the country where we transfer personal data. And the next situation which we didn't discuss today, and actually maybe it's justifiable. It may be justified because it's very limited situation, so-called derogations of Article 49 of the GDPR. Derogations covered occasional data transfers, which are not which don't have repetitive or systematic nature, which are occasional, and we are not entitled to use derogations for regular data transfer. It's just some exceptional situations. For instance, we have trial in the court in third country and should participate in the court, defend our legal rights, and so on. It's not normal situation. It's not regular. It's not systematic. That's why we didn't pay too much attention, too much time to this Article 49, and mainly we should bear in mind the main principle and the so-called traffic light regime, as perfectly described in this scheme.
Yeah. Thank you, Denis. So I remind everyone that you'll get this handout, this diagram of traffic light for international data transfer if you registered for the conference. So if you are not, please go ahead and go to the GDPR day.com to register there. You may do it post factum, post conference too, so we'll send it anyway. And right now we we go on to the conference, but the topic of international data transfer would still be here during the consultation, the express consultation that we will have in almost half an hour with Christopher Schmidt, Denis Sadovnikov, and myself. So you could write down your questions in YouTube chat. So we will channel those questions to Christopher, Denis, and we'll try to answer them. We will also, you can also write me in private message if you are my friend in LinkedIn, so go and find there if you don't want to ask your questions in the chat box. So thanks, Denis, and see you in half an hour to continue the conversation about international data transfers.
Thank you, Sergey. See you.
Thanks. And next speaker for today is Alina Voitukhovich. She's IP/AT and privacy lawyer at Palter. She's certified information privacy professional Europe. She works in a company that is a co-founding company of ecosystem of mobile applications. It includes, among other such applications, at Flow, Lensa, and she takes care of intellectual property, clarity, and ensure product compliance with applicable law. And those laws also include the GDPR and other privacy rules and regulations. So Alina, you may turn on your camera and start share your screen, because the topic that you would cover is very interesting and refreshing. Because usually when we speak about the GDPR, we speak about privacy law, we mostly focus on the risks for the company. Of course, we focus on the risks for data subjects, but we keep in mind the risks for the company, which are fines, hefty fines. But in your presentation, you would probably argue that fines is not the only thing privacy experts should be taking care of, and class actions are also important. So let's see your screen share.
I think you can see it now, right?
I don't see it right now, but maybe it's okay during the transmission, but maybe you could reshare it again. So I can see that you has started screen sharing, but I don't see it on my screen. Sorry, guys, if you see this screen share, it's okay. Now I can.
It works.
Okay.
Yeah,
Great.
thanks a lot for the presentation. It's all correct. And I won't argue really that GDPR fines are nothing. That's the first disclaimer that I'm going to make, actually. But I just want to make sure that we cover all the risks. Yeah, and as you have correctly said, I work at a technological startup, well, rather at an ecosystem of startups. And I'm an in-house lawyer. And you know the story of all the in-house lawyers, where you should not have like one specialization, but you should be all at once and to cover all the risks. Well, at our legal team, we can afford ourselves a bit specialization because we have several team members. And that is why we could afford it. I have a specialization of IT/API and privacy. But still, you have to cover all the risks, and it doesn't stop at GDPR. And it's also one of the good disclaimers to make that there is one great misconception actually out there among all the in-house lawyers. It says that if you're GDPR compliant, you're compliant with all the privacy laws. You don't need to read anything. You're just cool because it's the strictest laws ever, and you will be covered, which is not the case, actually, as it turns out. And USA is a very, very interesting jurisdiction. If you're working as a global business, well, I may share my experience as well in Palter do. It's an international business. We have mobile apps, and surely most of the customers, most of the users actually do come from the USA, Europe, and the UK. Maybe Australia, maybe Canada, maybe some other countries, but these three jurisdictions are the major ones.
And you are located in Europe, right?
Yes, 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 that's correct. That's correct. Although some of the companies are located in the USA, actually. You have to cover all the risks from all the standpoints because basically you still target the Europeans, the UK residents, and the US residents. And there are plenty of interesting cases to look at in the USA. Interesting from the standpoint that it's not this clear compliance path, which you just go checkbox by checkbox. For example, we have the records of processing activities, we have transparency, we have all this stuff, and we're covered. But you have many, many old laws that people try to apply to the new technology, which is sometimes strange, but sometimes the courts of the USA are actually very vote in favor, let's say, of such application. And the companies, these businesses that didn't know that it could be applied in such a way just lose lots of money. Some of these laws do not really cover, let's say, new technologies, and its modern application is not even proved. We will cover these laws, but the risk still exists, and the litigation fees also still exist. Here we come to this interesting slide. I've added it to just speak about the reality that we live in. There are different kinds of law firms, as we know, different kinds of people, different kinds of ages, and so on. Ages is the Attorney General for different states. And the reality is that many Attorney Generals are very eager to build themselves a career based on pursuing some case on some big tech company. Many law firms are very eager to participate in many class actions based on these very easy cases where you can just litigate and litigate for a long period of time over some very, very strange application of the case to the modern technology, which is not even proved. It's not even proved, but the cases exist and the litigation fees will exist as well. And probably it will turn out that they are right. They say that it's called civic mindedness, that they promote consumer protection. It's very nice simple, I would say. It's very cool to present yourself in this way. But I think that there's a very, very gray line between this civic mindedness and the moment when the company, the law firm really becomes kind of a troll law firm, which just gathers these class actions, gathers the plaintiffs, and just uses templates for some BIPA claims or some other claims, and just suits all the companies that kind of fall under this particular criterion. So as we have limited time, I have chosen these three topics, which we will cover. It's Video Privacy Protection Act, it's UNRWA Civil Rights Act in California, and it's Biometric Information Privacy Act in Illinois. I've chosen those three because there is a threatening number of class actions, honestly, in the USA right now, both on the US companies and on the other companies that just target the individuals from California or from Illinois or just from the USA. Which is why if you operate in an international business and if you are targeted as these individuals, you are at some kind of risk. And honestly, all these three laws are applied absolutely normal activity, as we would say. And in my personal opinion, I wouldn't say that they're very straightforward. Also, one disclaimer that we will see many settlement decisions here. Please don't think that settlement always means that the company should be blamed for that it's guilty. Usually the companies go for settlement just in case the litigation fees are too high, because they are too high indeed, just for litigation and for your litigation lawyers, attorneys. And litigation usually lasts for several years, which makes your litigation fees of 1 year, let's say X5. And it's just a horrible experience. That is why many companies settle. And also due to the fact that it's pretty much, let's say, they're not sure if the decision will be in their favor. That is why sometimes it's the most favorable idea to proceed with. As I said, we'll start with the Video Privacy Protection Act. What could go wrong with these very old laws? It was enacted in 1988. It's a Reagan-era law. So it was targeted at video tape service providers, at this VHS cassettes. And basically the idea was that such service providers cannot disclose the personal data of their customers, of the people who took this particular cassette or this particular videotape. The statutory damages are $2,500 per consumer, yes. And just in the recent years, I would say it's 2021, 2022, and this first half of 2023, it's already actually more than 100 class actions filed against companies that offer video services that track the activities, that actually put tracking pixels to track the video activities of their users. Yeah, it's basically just the modern application. Tracking pixels. If you don't know what it is, I will tell you it's just a very small HTML code which is embedded into your website. It looks like this, you know, these very beautiful landing pages where you just open the website and you see some video of something very nice, beautiful, looks engaging, looks nice, and it has some very, very tiny pixel, which is not from that website, let's say, but it's from Meta or from TikTok. They get the information about the user's IP address, about the user's device, operating system, the video that was viewed, the clicks on this video or on the advertising in this video, and so on. Just that basic information we know all about. All the marketing teams, if there are any, I'm absolutely sure they know about it. Cool case, IHOP case. IHOP is a chain, it's a US chain of restaurants that specialize in breakfasts. They made this very beautiful landing page for them with some egg benedict that was pouring very beautifully. And yeah, one of the serial plaintiffs, well, serial because this particular plaintiffs actually filed, I would say that's a good dozen of such lawsuits, more than 50, to the companies. They filed a lawsuit that they have a TikTok pixel, and it's such a far stretch that it says that due to the fact that TikTok actually shares the data with People's Republic of China, they kind of share the data to China, it's unlawful, and they are videotape service provider just due to the fact that they had this particular video. As you know, it's not strictly the case because they actually provide the services, restaurant services, right? But still. And yeah, they had a huge settlement of $2.5 billion plus the attorney fees because FYI, certain states in the USA do not provide for, they like split the attorney fees. Like you have to pay your own attorney fees and the plaintiffs have to pay their own attorney fees. But certain states like California, for example, they would assign all these attorney fees to the party that, for example, is proven as guilty. In this particular case, they chose to cover these attorney fees alongside with the settlement amount, which is kind of huge. When this presentation will be shared, you will be able to go to the link to the lawsuit to read it. I like reading lawsuits a lot, especially such lawsuits, because it's lots of fun. Honestly, it's not purely legal stuff. It's just a mastery of nice writing, I would say. Well, just ordinary application, right? And they're not the only one, as I said. More than 100 lawsuits are filed. These are the recent ones. Michael Kors actually was sued. I think it was either the end of May or the beginning of this June. Either for Meta Pixel or for TikTok Pixel. And Meta and TikTok were sued themselves as Pixel's service providers. Like they gather this data and so on. Actually, Meta was sued with some other company, which was kind of data controller of their website. And they just inserted this Meta Pixel. And it was said that they kind of acted in collaboration to collect the data of the viewers and like to use for Meta's own profit. Yeah, as I said, it sounds pretty much in line with the wording of the law, but from the very spirit of the law, it's kind of controversial, I would say. and weird when we read about it now. Also, there is a very nice website I wanted to share with you. It's classaction.org. It's also kind of fun read. There actually the group of attorneys investigate the different matters that are brought about by the public or by themselves. And you, as a general member of the public, usually from the USA, you can participate in these class actions just by saying submit your own candidate. Yeah. So here are just four cases, which could be the next ones. They're still investigated, and most of them are from all of them are from 2023. It's BuzzFeed, Udemy, NBC Universal, and Hulu. All of them had some kind of video which was playing. Well, yeah, NBC Universal and Hulu are actually kind of video providers, right? But yeah, Udemy has courses, maybe something else. And BuzzFeed, I don't know, probably some nice landing page with some very beautiful video. So yeah, they could be the next ones. I also saw an interesting, it's called advertisements in the Instagram of this actually class action org. They have very nice marketing campaigns. The advertisement stated, like, if you used Udemy for this particular amount of time, try to submit to our class action against Udemy. Nice stuff. Next one. Yeah, we're done with VPPA, which is very, very interesting. And now we go to the UNRWA Civil Rights Act. It's the act that is in California. It was enacted back in 1959, which said that it's also very, very, very old. And interesting application of this act, but also not just this act, but also of some other acts across the United States. This one is just one of the most, let's say, popular. It says that you cannot arbitrarily discriminate other people based on some protected data. One of the most popular data components here are either age or gender. Most of the cases are based on either of them. And interesting application, as I said, is that in several states of the US, ladies' nights where you can go to some pub or to some club and you're granted as a lady, for example, one free cocktail or something like that, are actually prohibited in California due to that act, and also in Pennsylvania, Maryland, and I guess somewhere else. That's just a fun fact. And here, two elements must be proved. It's first the denial of service. If you don't fall under the particular, let's say, age category or under particular gender, and as the case goes for most of the US acts, it's the actual harm that should be proved. However, there's an interesting however that no harm should be proved if you claim that you need just 4K recovery. Nice. Here are two prominent examples with both data categories, as I mentioned. It's Bumble and it's Tinder. I love this, the cases with these apps a lot because they are really prominent, and not only in this particular act, but in many other. And it's really interesting to see how these cases are resolved and so on. But here, as we see, they're both were settled. It doesn't mean that it could be proven that they're right or wrong, but still. The first one is against Bumble. As you know, it's this dating app where the women message first. Basically, men just merely didn't have an opportunity, and in certain jurisdictions, they still don't have the opportunity to message first. A straight man, yeah. Not men that are not interested in women are allowed to message first. And it was said that Bumble discriminates against straight men, and the settlement was $6.2 million. It's not that high in comparison to the highest GDPR fines, as my topic was saying, topic heading. But still, it's pretty much a lot, and I'm sure they had lots of litigation fees, attorney fees on their side, because this particular matter lasted for, I guess, around 2 years of the investigation, of the discovery, and of the discovery of all the matters. Another case is with another dating app, which is more popular in our jurisdictions, is Tinder. And it's an interesting case of dynamic pricing. They do implement it a lot based on different data categories. And this particular experiment didn't go well. It was not an experiment, well, it was rather released to all the users, and it basically provided different prices if you fall into the category of people that are 30 plus. It was almost 2x in comparison to the category of people that are 30 minus. That is why they had a settlement of around $11.5 million. Quite a lot. The case is very prominent after that particular case. As far as I know, many companies started to review their pricing policies because it was pretty much obvious to implement this, because sometimes you can try to state that, for example, this 30 plus category has more income and they have more payment power, let's say, but it's just against the Unruh Act. It's just arbitrary discrimination. You cannot state it for sure. It's not, let's say, fixed fact. And we see the settlements. Just to be sure and just to be clear on this particular fact, it's still okay to provide discounts, for example, or different prices for the protected categories of people based on age, like, for example, elderly, which is really elderly in this particular state, or, for example, which are students, which are really students in this particular state. And it's recognized, for example, by the legal system of that particular jurisdiction, but not arbitrarily, like, for example, 20, 30, 30, 40, and so on, just these cohorts of people. And the third one that I want to touch upon is BIPA. It's called Biometric Information Privacy Act. It was enacted in 2008, and it contains private right of action. Private right of action means that people can bring their private action, unlike some other laws in other states where just the Attorney General can make an action. It covers the biometric identifiers, and biometric identifiers are actually defined extremely broadly, especially from from maybe 2016, 2015, I would say 2016 and 2017, I would say, as we see on this particular scheme. It covers retina, iris scan, fingerprint, voice print. These all are pretty much customary for all the other data protection laws around the world, and also face geometry, which seems pretty much customary for us all, but the application, the modern application, as always, is just fascinating. What you have to do if you fall under BIPA is inform the users transparently, develop a retention schedule and inform about it, and receive a consent for such data collection. Now let's look at the modern application of this nice law. Yeah, it's a twist. I will go back to it. Here it goes. Just 4 actors among, I would say, more than 100. Most notable, most known, it's Facebook. As you remember, this feature, it still exists, but it's not turned on in everyone's device, where you just posted a photo and it said, oh, I see it's you on that photo, or it's your friend on that photo. Would you like to be tagged, or would you like to tag your friend here? Yeah, it was not recognized, but it was claimed that it's actually biometric identification under BIPA. And they faced a huge lawsuit, which, as you can see, resulted in a 550 million settlement just over these tag suggestions. It lasted for a lot of time. They struggled a lot. They had a huge process of investigation. And yeah, they settled in this particular amount. As you can see from all these cases that I presented, all of them are ended in settlement, except for Tinder, which was just hit with BIPA lawsuit in the end of 2022. And I think it will also be ended in settlement because there are no definite cases actually here. And it's not definite whether this really applies to such let's say, identification, biometric identification cases or not, whether it's really considered as biometric identification. Another case was Snapchat, which, as you see, resulted in 32 million settlements, just over filters. You know, these filters, very nice, which make you beautiful and so on, just because it had some, it puts on you certain points, for example, on your nose or on your lips, and it could make your lips, I don't know, red or something. Yeah, the plaintiffs also alleged that it's biometric identification, and that is why it was claimed. TikTok, just the same, the settlement even bigger because the bigger exposure suddenly, and Tinder was hit over the verification photos. If you want to have this, not checkbox, but how it's called, a tick near you, that's you have a verified profile, you need to upload some photos, and it kind of scans your photos, gets a face scan or something, and that is why plaintiffs say that, yeah, that they actually collect biometric identification. And nice twist here. Why you should be worried about it if you have some trying technology or something that is connected to the face and that puts certain, for example, points on the face. Because the damages, as you can see, is just 1K-5K. 5K for intentional violations, 1K for not intentional. Illinois Supreme Court in 27th of February 2023 ruled out that these damages actually accrue per each violation. Like each violation means, for example, in the case of TikTok, it could be each filter. In the case of Facebook, it could be each tag, each photo scan where it put a tag, and so on. That's a very interesting twist, and that is why you see such huge settlements here, and we will see even huger settlements in the Tinder case and in many other cases that are still pending. I'm pretty much sure about it. And yeah, I wanted to conclude on the fact that it's always a risk. It's not definite that these particular cases will be ruled out in the consumer's side, for example, or in our side as a business, but we should be aware of that. And if you're aware, you can take certain precautions that would make your particular startup less risky, let's say.
Thank you. Thank you for great presentation. So the main idea would be tracking all those requirements and assessing the risks, especially if you work in the United States. There is a question in YouTube. I don't think that it was related to this presentation, but it was not actually in YouTube, it was in LinkedIn. So we have this transmission going on in LinkedIn, and over there, a person asked a question: what is the best tool that you could suggest for compliance purpose? So let me paraphrase this phrase. What is the tool? What are the tools that you use to assess the risks in different jurisdictions and actually to kind of map those requirements to your application and to your technologies?
I would say it depends. Either it's compliance or just risks identification and assessment. As to compliance, we have all these acts which we know that are 100%, let's say, applicable to us. We know that GDPR applies to us. We know that CCPA applies to us. We know that VDPA. That's for sure. I usually make myself kind of action plans and checkboxes of how we should be compliant in this particular, let's say, jurisdiction. And basically that's it. And there's a whole lot other risks, as I just presented, where you do not think that you actually fall under this, like this Video Privacy Protection Act, right? It's just for video service providers. But it seems that if our Palta application wants to have a very nice landing page with some very nice video there, then we could be under that particular, we could be sued basically, and it would be huge. So here, I just monitor all the cases, especially such that apply to us in respect of privacy and consumer protection for sure. There are also huge class sections in respect of accessibility, for example, and in respect of publicity rights and all this stuff. And just such monitoring of the cases, especially class actions, actually helps to at least mitigate such most common and high risks that could actually play out.
Great. Thanks for the answer. So let me check if we have more questions coming from YouTube. For those who are watching right now in YouTube, this is the last chance to ask the question to Alina. So there is a comment. Thank you for covering fines and class actions topic in such an energizing and spectacular manner. Undoubtedly, it was full of insights for all of us. So just thank you to you. But I have my personal question. You selected those laws because they are the most risky, or they are most, I would say, out-fashioned and not compatible with current digital age? Or what is the reason why you selected those cases for your presentation, those particular cases? Does it mean that we need to take those requirements as the highest priority when researching the requirements in different jurisdictions where our company working in?
I would say that I've selected them just for the very simple reason. It's a huge rise in such cases in the recent years.
Okay.
And it means that all these beach trolls or civic-minded plaintiffs just do pay attention to these particular matters more than to the others. And yeah, I think they're just related to privacy, and yeah, they were old and very unnaturally, let's say, applied to the new technologies. But yeah, there are many more in consumer protection sphere especially.
Great, thank you, Alina. I'm speaking to the YouTube viewers. Please don't forget to subscribe and to hit the like button, because right now we are moving to the next part where your active participation is very important. So maybe more people join. Right now we are watched by 290. Let me check the statistics. 300 viewers. Well, round number. So 300 viewers. So probably some viewers have questions about international data transfer. We already covered the main principle of data transfer, and we'll share the flow chart of the traffic lights for international data transfer to those who are registered. But right now, I invite two panelists, Denis Sadovnikov and Christopher Schmidt, to speak on the topic, not actually to speak on the topic, but rather the answer the questions that we collected from you. And let me start with introducing our panelists. First of all, Christopher Schmidt, who is FIP, CIPP, CIPM, CIPT, CDPO. This is the French certification. CDPO, this is Brazilian certification. Wonderful. And attorney at law, in-house lawyer. We all know you from your LinkedIn profile, and the new information that I learned from the biography that Chris is a chair of IPP, CIPP exam development board. Right after our panel consultation, we will have a panel discussion devoted to the passing CIPP and CIPM exams. So this is the person responsible for those tricky questions in IPP. And he's also an expert on data protection matters by the Council of Europe. So thanks, Christopher, for finding time to join our conference. Another speaker today is Denis Sadovnikov, who actually presented the overall principle of international data transfer, gave the definition of the data transfer, and showed the rules of selecting proper mechanism. Denis is AI and privacy lawyer, global privacy team lead, and senior data protection legal counsel at international IT company. He's an international expert in humanitarian law and human rights, member of IPP, and has a lot of certifications issued by IPP. And finally, myself, I'm a founder of DPO Europe GmbH, which is the organizer of the conference. I'm a data protection trainer and a principal consultant of this company. I also have the professional managerial and technological certification in the area of data protection. But when I teach the classes devoted to international data transfer, I usually turn the floor over to some of my colleagues who constantly practicing drafting SCC, standard contractual clauses, or assessing jurisdictions. So I'm not a big expert in international data transfer. I would say a professional by necessity in this area. So let's go on with the questions that we received. And please don't forget that you may ask your questions in YouTube chat. So in YouTube chat, you can channel your questions, but right now we are going to answer some of those questions that we received recently in private messages. So let me copy paste the questions and read them to you. So let me.
That's really on-demand answering, live questions, live typing. I like that. Hi, Denis. Hi, Siarhei.
Hello. So how is the weather in the place where you are now?
It's hot at the moment. It's really hot. It's like lots of sort of temperatures. I think it might just change overnight or something. So yeah, summer's kicked in. How about you?
Nice to see you, Christopher.
Hi, Denis.
Hi.
Yeah, Denis says that in Belgrade it's a nice warm weather. And right now I'm in Batumi, where it's like shower rain going on, and I have like open doors, but noise cancellation in Zoom works perfect, so you don't hear those rain noise, and you know, all this traffic outside. So after this, you know, weather broadcast, let's go on to the questions. So the first question to you guys: we are a group of companies registered in Cyprus and Singapore with a head office in the UAE. Well, quite complicated structure. Can we use SCC to transfer European customer data to overseas offices? Or is it forbidden and we need to use other mechanisms like BCR, obtain consent of subjects? Right. Well, it's quite complicated question, and I hope the author of the question might elaborate on that, because we might need some additional information to answer, but we might also make the assumptions. So let me draw European Union. We have the company over here in Cyprus.
Cyprus, yes. Actually, I think that issues is clear, but maybe the person who asked us a bit misunderstood the concept of SCC and the concept of data subject consent, because data subject consent is not a mechanism of international data transfer at all. It may be used in accordance with Article 49 in some cases of derogations, but it's not an instrument for regular data transfer.
So let's assume that we have data subjects who are inside the European Union, right? And since we have the company in the European Union, let's assume that the author's company collects the data in Cyprus, right? And then shares it with the group of companies. What would be correct answer? What would be correct answer for, like, correct advice that we need to give to such company.
Dennis, you want to start, or
yeah, go on. Yeah, that's Christopher. So what is your opinion, Christopher?
Sorry, I thought it was Dennis to take the lead here.
I'm waiting for your opinion.
Well,
instead.
okay. So yeah, that's a structure that sort of takes definitely some mental capacity here in any case. So we have the Cyprus entity registered in an EU member state, of course. We have Singapore, which is outside in that case, and we have the main head office of the United Arab Emirates, UAE. EU SCCs use, or can we use SCC, which is just a general sort of question. It's not specific what type of SCCs we're using. We know there's lots of set of them. There's the DFC set, and Emirates there's the ADGM set. There is the Asian model clauses for the whole Asia Pacific region. So first, there's lots of different sets of SCCs. There's not just EU SCCs or EU Commission SCCs. So in general, SCCs as a means of transfer, of course, generally they sort of come into play and they could be used. It depends, of course, on what transfer we're looking here. I think we don't know what type of transfers specifically we're looking here into that account. So there may be transfers between the Cyprus entity and the UAE headquarters. There may be transfers between the Cyprus and the Singaporean entity. Maybe transfers in another sort of way as well. So these sort of possible scenarios need to be sort of clear cut out and then individually assessed by what's going on and what type of transfers going on there.
Yeah.
To Dennis' point, of course, consent, I think that has been well advised by the board for the European Data Protection Board for some time now, and also the latest meta decision by DPC. Consent may only be an exception. It's not to be used on a continuous basis. So getting blanket consent, even if it's explicit, so you sort of very fairly allude to the risks and make a very sort of broad statement of what can happen to sort of data being disclosed outside the EU or the EEA, the European Economic Area. So GDPR kind of land. It might still not be a solution for continuous transfers on a large scale. So this might only be some sort of interim solution, but nothing that will sort of see the day for a longer time, that's for sure. For the SCCs as such, on a very general basis, I recommend looking into like the specific sets of SCCs, of course, because the EU SCCs, the Asian SCCs, the UAE SCCs or model clauses have some similarities, but they're not fully sort of identical, of course. They have different requirements, they have different sets of rules that apply. And so I think for the Asian SCCs, I saw lately comparison, some sort of joint guide on the Asian model clauses and the EU SCCs. I think this was the commission that sort of did that with the Asian kind of community together. Very, very helpful guide. So you can sort of see and compare both sets of SCCs, to what extent you could use one set or the other set for these types of transfers. But of course, you need to look at any sort of any different set of transfers or transfer scenarios, as we just pointed out here, 1, 2, 3. That sort of would be required. If it's the sort of number one, so the Cyprus to UAE scenario, I think in that case, EU SCCs in general would be possible. Of course, with all these sort of precautions and measures that are required, especially clause 14, so the TIA, it's one of the centerpieces of SCCs, no transfer without assessing and documenting your findings of the transfer impact assessment. That's sort of the sort of very least thing to say. For the other situations, depending on what type of like data you're transferring, is it personal data from EU data subjects? Is it personal data from subjects in Singapore? Is it, of course, that depends. And then sort of the respective SCC model clause would be needed to conclude. I think the most interesting part here when it comes to SCCs, and I'll just stop right there so we have time for the rest of that, is the question to what extent you can use EU SCCs also in non-EU sort of contexts. And this question has not been very well, I would say, deployed for a long time. For many, many years, as I know in prior practice, it's been the gold standard kind of EU SCCs would kind of heal everything and kind of cover everything. But as we see that the Asian sort of network and community, and then other communities as well, the Latin American sort of network cooperation has some model clauses as well. They might be to a certain extent interchangeable, but they're again not fully identical. I would like to see DPAs or at least sort of regulators to speak up a little bit more on what type of sets you can use, because it cannot be very transparent solution to have at least 2, 3, 4 types of SCCs applying to the very same transfer in that case. That just sort of makes a duplication of obligations, but doesn't make it very transparent. So that's is the issue. If we're looking at BCRs at like a different sort of set, that's of course just intercompany transfer. So BCR could be an option if it's for the intercompany transfers, again under the applicable laws. So the GPR, as far as GPR is applicable into the specific transfer, might not be the case depending on what's happening on transfers 3, unless it applies extraterritorially. But again, BCR would not be a solution if it's like third-party providers or someone outside of the group of companies, of course. So that sort of estimation should be made. So there's lots of sort of questions to dig into that. Of course, I'm happy to write. So I'll just have you. Dennis, anything to add, or does that cover something?
Yes, Christopher, thank you. You explained almost all issues sufficiently clear, but I'd like to add that in the given example, seems that SCC may be the most appropriate tool to transfer personal data from Cyprus to outside the European Union. And it's not prohibited, of course. It can be used, but together with TIA, of course, transfer impact assessment, because we should ensure that our SCC are enforceable and recognized in law of the third country. And PCR may be an alternative tool, of course, but the group of companies should be approved BCR in place for this.
Yeah, and usually it's a lengthy and quite expensive process, right? So most of the companies use SCC as a tool for the international data transfer. Yeah, it's a quite straightforward example where you have the group of company and you are lucky to have a European entity that is transferring data outside European Union, because in that case, even if you are joint controllers, then you would just pick the correct set of SCCs and go on with controller modules. But recently, not recently, 1 year ago, I had a situation when we had this quite similar case without European entity, and actually I'm wrong. It was a European entity, and information was transferred between the entities, and there we had
companies in Ireland. Actually, company is registered in Ireland. It's establishment in Ireland. It's maybe first criteria of applicability of GDPR.
I didn't see it in the question that was in Ireland. So the question was just let me recollect this situation. It was quite similar, and the issue laid in the joint controllership.
Sorry, sorry, it's another question. I just missed.
Yeah,
it's the next question. Yeah,
it's the next question about Ireland. Yeah, and the question was that there is no SCC set for cases when GDPR is applicable because of the context, because of the Article 3, Paragraph 1 of the GDPR. So when companies act in a single context, and this group of companies shared like internal personal data constantly, and supervisory authority took the position that, okay, you are joint controllers here, and the companies, the data importer is a joint controller and is under the GDPR on its own, like by the Article 3, Paragraph 1. And since this company is under this processing by the importer is in the scope of the GDPR, we could not use current set of SCCs. Is it correct? Like, is it correct, Christopher? Is it the case when you are under the GDPR according to Article 3, then you are limited with using this set of SCCs?
I think the board alluded to that problem in its opinion, David, maybe a year ago or so, on sort of the notion of a transfer. So what constitutes a transfer? The notion of transfer on GDPR is a very interesting, controversial paper, but at least an interesting sort of starting point. And I think at one of the latest pages, the last pages of that document, they sort of point to the issue that under Article 3.2, so when the GDPR does not apply by means of an EU establishment to a given entity, be it a processor or controller, but it applies by means of Article 3, Paragraph 2, so the offering of goods or services or behavioral monitoring of EU DevOps objects. There's no specific set of SCCs that would apply to that type of transfer. And they said, well, in that case, you need to put something up. We don't have any set of SCCs for that case so far. What you need to put up is some transfer sort of mechanism or transfer instrument by yourself, but you should be taking care to not duplicate sort of the obligations, because such a controller or such a processor outside of the EU EEA which sort of becomes subject to GDPR by means of Article 3.2, would already have lots of these obligations by itself from the very first articles of the GDPR, the principle, of course, Article 5, following data subject rights, following. So lots of these things would already apply to such a controller or processor outside the EU, EEA. In that case, again, the SECs don't make much sense, and they say also by themselves in the very beginning of the new SECs that it wouldn't apply to that side. So the SECs at that case apply to a processor or controller outside the EU that is not already subject to GDPR by means of Article 3.2. So again, yes, that's sort of an open issue. I think there has been something proposed, some draft, but not published so far from the EU Commission on the 3.2 set. It might still take a while, I think. So we might not see that in the next future. But again, that's one of these open cases where you might have it. In that context, if it was here, maybe, for example, the UAE entity, and if they were subject to GDPR, just hypothetically speaking, not assessing, of course, but if that was the case, the GDPR sort of was applicable to the UAE headquarters. In that case, one could think to make some sort of international data transfer or intercompany data transfer kind of agreement and replicate these obligations to the extent they do not already apply to the UAE, but still make sure that sort of we get that. However, such an instrument is, of course, not under Article 46.2, but under Article 46.3. So normally, although lots of companies, I think, don't do that, you would need to go to your DPA first, or the DPAs that are competent in that case, get authorization on such transfer mechanism, and then sort of go ahead and use it as ad hoc clauses or ad hoc contracts, however you want to call it. But that's sort of the interim stage that we're in between the 3.2 GDPR cases, so where the GDPR applies extraterritorially, and then sort of the conflict with the transfer kind of notion, as the EDB at least understands it nowadays, is still some sort of open issue. That's the least to say. Yes. And maybe just one further thought, I think, which is interesting from what you said, Siarhei. I think looking at these kinds of transfers, and if you really want to assess transfer by transfer, and there's lots of sort of details to look at and lots of different scenarios, who's where, what type of SEC is applicable, etc., it becomes clear that the more you are able to limit and to keep certain transfers, of course, I mean, sounds a bit sort of simple to say, but again, here we go. Keeping these transfers limited to what's really necessary is the first step to do that. So avoid unnecessary transfers. Lots of things can be done in the EU itself, and the HR data, payroll data. Normally, that should be doable all within the EU. There shouldn't be sort of critical need to transfer all of the data and look at like what's really necessary for your service, for your specific sort of scenario, what to transfer for. Because the more you transfer, of course, the higher the risk, of course, and the more you have to document, the larger, the more complicated, the more complex as well the issues that the TIA might reveal will become. So try to sort of boil it down to what's really sort of crucial and keep the rest within. I think the same applies to Singapore, UAE, China, US, other companies, or at least other countries where we're running these risks. So the more we can keep it a bit sort of contained in a solution, the easier it might get.
Yeah, completely agree. Besides, it's like data minimization principle, not just international transfers, but any transfers increase the scope, or the risks, and the data copies. So yeah, let's move to the next question, which is about Irish company. Let me read it. So our company offers a service to optimize marketing campaigns. Services available worldwide, and our company is registered in Ireland. Sometimes we approached by clients from the US to analyze data obtained from EU users. So it looks they are data processors. Initially, data subjects themselves gave their data to US company. Once the data is transferred to our service, we process it and generate a report, which is then transferred to American company. Reports may contain users' personal identifiers. So the reports that they sent back to United States contains personal information. Okay. So is it necessary to enter into an SCC for such data transfer? Can initial data collection exempt us from the obligation to comply with the rules on data transfer? Did you get this case? Or should we draw the...
Actually, I've got the main idea of the question, but it's better to draw the scheme, because it's not easy. And
let's
First of all, we have an establishment in the union in Ireland.
Okay, this is establishment of data processor, but let's start with the controller. It looks like this American company is a data controller. So the American company collects data from data subjects. So this is international collection of data. It's not data transfer.
It's not transfer, yes.
Yeah. Then we have this company that is asking the question. So this is the processor, and we have a personal data going back to the European Union. Then this data is transformed into some kind of report. Let me draw a report here. And then this report is sent back to the United States, and this report may contain personal information. So the question, as I understood the question, please correct me if in the chat box if I'm wrong. Though this question I got it in personal messages in LinkedIn, but if you watch, please correct me if I'm wrong. So the question of yours is whether this data transfer of this report,
so so-called reverse data transfer.
Yeah, some kind of reverse data transfer of the product of the processing is an independent data transfer, and it needs SCC plus TIA for United States.
It's interesting. We have in this example two different entities, controller and processor, and both are subject to GDPR, but based on different criteria.
Yeah.
The first, the processor is subject to GDPR in accordance with the principle of establishment.
Yeah.
And the controller is subject to GDPR in accordance with the principle of extraterritorial application.
Yes, this is Article 3, Paragraph 1, and this is 3, Paragraph 2.
Yes, exactly.
Probably A, or maybe B, it doesn't matter. It's the second paragraph of the third article. So they both under, I mean, not their processing is under the GDPR, but the question is whether you could divide this, you could single out this processing, reverse transfer, and treat it as a separate data transfer. Yeah, it's a puzzle. I don't have this answer sincerely. Maybe some of you have, or like educated guess on what to do in this situation.
And also, it's interesting point that it's mentioned in the question that reports may include identifier. It means it may include or may not include.
So let's make this situation worse. Let's say that they have this identifier. So then it's personal information. So if it's not personal, then it's not under the GDPR and Chapter 5 of the GDPR. Then no need in SCCs or other mechanisms for international data transfer.
But let's assume that the information is personal, is of personal nature.
Yeah. So it's a quick. So it's a good question. So we don't transfer the initial set of information. We potentially transfer new set of information because we probably, as an analytical company, we do some analysis on our site, and we might create some additional information about data subjects. For instance, we could profile data subject. We could make make assumptions about the individual, or I don't know, enrich this information with some additional data. It's a tricky question, really. I don't know the answer. Maybe Christopher, could you help us with answering to this?
I don't know if I can provide the answer. I can provide my thoughts on it, my 2 cents, but I don't know if they are helpful. So a couple of assumptions here. I think the first of the yellow sort of arrow back to the company, US-based company, the controller in that case, I think most likely they will contain personal data, be it identifiers, be it direct names or something. I mean, the marketing product, as far as I know, I'm not a marketing expert, but I think the true value of like such a service rendered by the EU processor in that case would be that they give some more enriched data, some more insights, so that would be more targeted at individuals, saying it's a very sort of, it's a fully anonymized report, just giving some statistical data over like the marketing recipients might not be so valuable. So I think we can assume safely that like this transfer will contain personal data, and then sort of going stage, sort of like by stages of processing. So like from first moment and then following on. The first thing that happens is that like we have a direct collection of data either from the data subjects directly, so they will disclose EU data subjects personal data to the US controller. That's the first stage of processing. That, of course, at least by the EBB notion of a transfer, would not be considered a transfer in that case, of course, because we don't have any sort of company or entity in the EU providing that data, but it's the data subjects directly providing the data. So direct collection of data, which is not considered a transfer under this notion, at least under Chapter 5 of the GDPR. So that wouldn't be a transfer in that case. Remember, there's these three criteria that the EBB sort of tried to develop, saying I think it's you need a controller or processor that is subject to the GDPR for the processing. That could be the US company. And then the exporter would disclose sort of the data by transmission or otherwise to make it possible to an importer. And the importer then is a third country, but we don't have a controller processor in the EU or anywhere else. We have the data subjects directly disclosing. So direct collection, that's good. It might be Article 3.2a or B, maybe 3.2a if they want to offer their products in the long run. That might be true, of course. Or services, maybe even 2b if they want to sort of monitor the behavior of these folks. Depends on like how invasive their marketing sort of strategies are. If they want to know where they are, where they're located, what they're interested in, like following their social network profiles, maybe like it could become another case. But let's assume that the controller, therefore, I'm sorry, but I think we need to make these assumptions here to make sure we get the case very well understood. The controller is therefore sort of subject to the GDPR, extraterritorially applying by means of Article 3.2, be it letter A or letter B. Either of those would be fine. We then have a transfer from the controller in the sort of US, so the US company. It's just a first arrow, the stop arrow, to the EU processor, which in that case would not be a transfer to a country outside of the EU EEA. So no need to safeguard that one. So number 2 is still looks like a transfer, but it's sort of back to safe haven, so to say. So we're back to EU. So no need for number 2 to be transferred under any transfer sort of mechanisms, because we're going back to sort of the safe harbor of the EU, at least technically. So that's good. And then sort of we come into question of the number 3, sort of the third transfer. Maybe that helps even like with question number 1. You see what we're doing. We're trying to look at every sort of transfer, like at every, like what's happening, follow the data, where is it going, where is it flowing, and try to safeguard everyone, like every transfer along this sort of this travel, this journey. So number three, we have the EU processor and it transfers kind of back, generate enriched reports, something but still containing personal data to the US company in that case, of course. I think in that case, the notion of a transfer would likely be fulfilled. However, we have the problem that the controller in the US is already subject to GDPR. And if you remember, so I think it's the third criterion would say the importer is in a third country, which is in that case true. So the EU processor would export to the US importer in a third country as a controller, great. And it's sort of there's no relevance of whether this third country importer is subject to the GDPR or not. The problem, however, is if it's not subject to GDPR, we would apply SECs and would be fine. In that case, it seems as if it applies to the US company for that type of data and that type of processing. So we don't have the SECs ready available at that point. We cannot use the EU SECs for that one, as we alluded to it further, as the EU SECs are not applicable to these cases where the importer is already subject to GDPR under Article 3.2. So what they would need to do, at least per ADB recommendation, is to conclude another type of light version of SECs, taking into account the fact that the controller is already subject to GDPR, but still providing transfer safeguards, or at least certain mechanisms, contractual, organizational, and of course technical measures as well. So safeguarding the transfer as if it was a transfer, without the GDPR being directly applicable to the US company. However, you can't just copy paste EU SECs in that case. That's impossible. But if you look at the opinion of the board, I just looked at the guidelines 5/2021. It's on the interplay between Article 3 and Chapter 5 of GDPR. And there on the last pages, you will find sort of at least the description of the power and the issue and the proposed solution of the EPB. Again, it's not perfect. That's the case that has not been sort of thought through or fully developed so far by legal means. But at least we're going there. And light SECs, of course, meaning that we still have transfer safeguards, but we respect the situation that the controller by itself is already subject to the GDPR.
Should we go?
Very long, a very complicated answer, but I think it's sort of, I hope it helps to a certain extent. That's sort of one of these pain points we still have in this context.
So,
sorry.
Would we treat this as SCC or CC, where you need to go to the supervisory authority and get the approval of this light?
That's the point. I mean, if you are not to modify, like if you use the EU SEC, you need to copy them. You can fill them out, of course, and leave out the modules that don't apply, but you cannot change the material provisions of the SECs. That would make a bit of different sort of transfer, at least not for judgment of our subjects, but I don't want to discover DPA if I change it to the benefit or to the detriment. So simply put, any material change of the SECs requires an authorization from the DPA. You cannot just sort of sign it and then go on with it. So what we're doing here is we're creating an ad hoc set of transfer clauses and a new kind of transfer mechanism for that individual case, which, however, under Article 46, Paragraph 3, would need prior authorization from the respective DPA.
Oh.
Unfortunately, that might change. I mean, once we see, who knows when, I don't have like very recent information on that topic, but once we have the Article 3.2 GDPR type SECs, you might have a standard contract which you can use without authorization, but to date, they're not available.
So approval of these contractual clauses according to Article 46.
So it seems like theoretically, SCC's instrument is applicable for this situation, but we don't have appropriate SCC for this case. And that's why we should go to the authority.
Yeah. So maybe the best way for practitioner, because it's quite strange, right? We are a company that follows GDPR, but if it would be a company that is not whose processing is outside the scope of the GDPR as an importer, we would just go with the SCC. So the company that has implemented some measures, hopefully, has to go longer path, longer way than the companies that that outside the scope of the regulation, which is quite strange and kind of problematic from the standpoint of of creating correct correct rules and like play level field for the businesses. Yeah, but this is the law. It's set law. It's set, but could we, as a practitioner, try to treat this as a single processing, a single transfer? So if we say, okay, this is the data, that this whole data transfer is the exchange of data between those companies, and we treat this as a single data transfer, then we would be able to avoid SCC altogether, because it would be treated as a data transfer from data controller.
I'm not sure that it's compliant with law.
Whether this reverse return of the information would be
yes, because first of all, we are not sure that the data which are reversed are the same that data which we receive from outside the European Union. The
just imagine that we
that is the same data set.
We included into the DPA. For instance, we have not received this information from the data controller, but data controller might include all the information that we produce as a data processor into the DPA, data processing agreement with us. So they say, okay, we provide you with this information, and we also know that you would create a new additional information, like kind of generate new information on data subject. So we include this information into our DPA, our data processing agreement. So please provide the necessary information security and other measures. And that's it. And treat it as a single transfer. Of course, I'm playing a devil's advocate role right now, because I do know that probably is not not really comfortable way is the most correct one, the most strict, yeah, but correct. Chris?
I mean, without proposing that as a first sort of, there is no silver bullet, so that case, at least not at that point in time. But consent in that case, if well explored and is explicit from that subject in that case, saying like there's a one-off transfer, there's one single transfer we're doing, we're sort of sending the data over to the EU processor, they will do X, Y, Z with the data, and they will then transfer it back to our company in the US. And the risk, of course, after having done your TIA and something is that we're subject to certain surveillance laws. It might be that sort of we cannot sort of guarantee or warrant sort of that your data won't be shared with governmental entities, and so that's the risk sort of involved. Explaining that and having received consent for that one-time transfer, I think is still a possibility, but it's a complicated sort of way to do it, of course.
So
sorry.
You had the option of the derogation, Article 49.
Exactly. If sort of you want to avoid sort of having that ad hoc clause and then 46.3 GDPR authorization requirement, going the long way with the DPA and having all that sort of rather administrative burdensome steps to do. Why not rely on consent again if this is one trade transfer? Of course, in the marketing context, and that's sort of is why I'm a bit hesitant to propose that outrightly here, is that normally they wouldn't just get a sort of status quo update on my profile and say, look, Chris is interested in this and that, and we're going to do something and have a one-time transfer. But it's more about a monitoring and continuous activity, because you will want to, or you would like to follow data subjects on their journey across their sort of career maybe, or their business interests. So it wouldn't just be one-time transfer. It would be rather maybe a continuous activity. But again, if it was just one report in a very specific set, I don't know, let's target all managers in startup companies dealing with AI in the health sector, for example, and you have like 20 data subjects, and it's just a one-time transfer. I think in that specific case, of course, rather that we have like all requirements met for that type of consent, so 49 GDPR explicit consent for the transfer, alluding on the risk, being very transparent about that, not just one phrase, but there needs to be more than that. It might happen, but it's not ideal. Of course, I mean that's the least to say. And for any sort of further transfer, I think we're in a debate on like how long can you rely on consent, and that will work again.
And of course, we can't rely on on consent and on derogations at all in the case of repetitive or systematic process of transferring data.
So far, we have no additional questions from the from 264 viewers that watch us. Maybe some people come up with a question. So until we get some question, what would be what would be situations that you would like to discuss, or maybe not situations, but like general news ideas on this topic of international data transfer? Any additional thought?
I was looking at sort of this kind of EU, I think it made sort of the past, kind of month, or maybe 2 months ago, in April or something, the EU General Court sort of decision, SRB, I think, versus EDS on the sort of transmission of pseudonymized versus anonymized data, and the sort of all prior judgment, remember like these old times back then, IP addresses, and like having the chance to re-identify data subjects. So what's the threshold to say, well, with the use of legally obtainable additional information, you can still re-identify data subjects, or you're unable, and therefore, at least for you, this type of data set is considered anonymized data. This is kind of keeping me up a little bit, because I'm kind of interested to see to what extent you could use that in the transfer cases, of course. So when you have like non-EU, non-EEA controllers or processes, and it's not doable in all contexts, of course. In the marketing context, it would be difficult, but there may be other contexts as well where you might rely on a pseudonymized, or in that case even anonymized, for the recipient of the data, so for the data importer set of data, and therefore we wouldn't be talking about personal data anymore. So we're not just out of Chapter 5, but we are out of like GDPR in total for that type of data, which is a very interesting case to me. and some technical developments that are sort of coming up even these weeks. But that's sort of what is like on my mind at the moment. Of course, looking at the privacy framework, privacy framework EU, yes, I think that's high on the agenda of many companies. Looking at the meta case recently, so I think yeah, it's like the weather. It's still a hot topic.
It's interesting. Sorry.
Yeah, it's a great point from you, Christopher. We may avoid the following of the following Article 46 and the whole Chapter 5 by just using anonymous information, by accepting from our clients, from US, non-personal information. This is something that I was speaking about earlier today, about this line between anonymization and pseudonymization. And with this development, with this case that you referred to, indeed, you might forbid data data recipient to re-identify data subjects. And in that case, basically pseudonymous information that you transfer to the marketing company in European Union would be treated as anonymous because it's forbidden for the re-identification is forbidden, first of all, and secondly, you are kind of the fact that you have the real IDs on your side does not affect the anonymity, the status of data as anonymous on the side of the data processor. Is that the point that you was making?
Absolutely. That would take the biscuit. I think the most, or at least an interesting point here, and that fine line is, at least as far as I see, and I know that the judgment, as far as I know, is not final yet. So there's still sort of the possibility to appeal, and therefore we might have a different outcome or some more color, some more contrast in the short way. But I think the fine line between personal and non-personal, and therefore anonymous or anonymized data, if it has been sort of transformed into anonymous data through anonymization, as understood by GDPR, we're not just linked. If I'm looking at recital, I think 26, it's not about just the all legal means you could use or all lawful means, but it's all the means that are sort of reasonably likely to be used. So even our contractual requirements saying you are not to re-identify the subjects, we are contractually prohibiting you from using additional media information or other types of identification to re-identify or at least single out or do other sort of anonymization kind of attacks to re-identify data subjects. I'm not too sure whether this would be in all cases sufficient, just a sort of contractual commitment from a third country controller processor to say, look, I'm warranting. I mean, it's a breach of contract in that case and could be sort of pursued as such under civil and contract law, of course. But from a GDPR point of view, I think we're looking at all the means reasonably likely to be used. And then a company, not looking at any company specifically, of course, but companies that are trying to get a lot of data, of course, have a genuine business interest in getting that type of information and would not be too keen on limiting themselves, saying, of course, we give you the guarantee we will not re-identify. I want to believe them, but I hope they sort of walk the talk, and that's the tricky question. So I think a contractual commitment might not be enough for that case. Looking at the GDPR mandates and Title 26, all the means reasonably likely to be used. That's a fairly high standard, actually, to say. Yeah. And I'm happy that the General Court has kind of opened the door a bit and looked at sort of that perspective again. I'm just not sure if it works in each and every context. Might be the case if it's a sort of smaller or medium-sized entity, company with a large sort of service provider running on data. First and foremost, I think it might be difficult to say we have a clause in this 200-page contract, and this will sort of safeguard that they will not attempt to identify directly or indirectly.
Well, great point, and it illustrates this, interconnection between different rules. So if you cannot avoid the Chapter 5, then you can avoid the GDPR, but by anonymizing data. Denis, you wanted to say something, but I interrupted.
Yes. I just would like to support your and Christopher arguments about the possibility to use this recent decision as a probably solution for international data transfer, but we should be careful with it, of course. And also, I would like to add that in the United Kingdom, where data protection regime is very similar to the European Union, but the practical approach adopted by the courts is more relaxed. And 15 years ago, in 2008, the House of Lords held the case Common Services Agency versus Scottish International Commissioner. And in this case, the House of Lords held that actually they offered the same position, the same argumentation as now we can see from the Court of Justice decision about the data, anonymized data, which shouldn't be considered as personal in the hands of third party, which don't have any access to any additional data set to identify data subjects. And in this case, it was held that it should be considered as anonymous data, not personal. But for the initial data controller, the data is still personal.
Mm-hmm. Interesting. So it actually supports this current case in the European Court of Justice. Sorry.
Yes,
but Court of Justice of the European Union is the correct name.
Yes,
right
yes.
now.
But in the United Kingdom, it was done 15 years before.
Okay. Yeah, European Union lags behind in some legal cases. Okay, so to sum up the answer to this last tricky case, first of all, thank you for asking this question. It's very tricky. It's very nuanced. So first solution, the correctest solution would be going on with contractual clauses and getting an approval from supervisory authority for this reverse transfer of enriched information back to the United States.
Depending,
second,
practically, just a little footnote on that one, depending on the authority you're talking about, and that really is something interesting as well. So it depends the reactiveness of authorities. There might be some authorities, I won't cite any, I didn't cite any companies, so I won't cite any DPAs specifically as well, or call out anyone, but there might be some DPAs where you get that confirmation, I would say rather quickly. It's more a matter of weeks or maybe some months, and there's some authorities where you can just wait a long time. So the practicability of that approach really depends on where you are or which sort of competent DPA we're talking about in that case. So it might not always be the best solution from that one. So when we sort of advised on the first or then the second approach, at least some consideration is, of course, not really advice we're giving here, but just considerations.
Mm-hmm. And
that
type
of consideration might then be sort of a useful documentation. Say, look, if I can't get that authorization in due time, I will need to rely on consent. If it is a one-off transfer, otherwise we don't have anything at all. And then what you're going to do, you just let it be and sort of let the business opportunity slide away because nothing can be done because the DPA doesn't react or because you don't know how to apply light SECs in the context of 3.2 GDPR. It's a bad situation. So, but just that sort of consideration from the tactical sort of perspective.
Yeah. So the supervisory authority we are speaking about is Irish supervisory authority, which is quite busy with investigating all those cases of Facebook, Meta, and others. So I don't expect that this approval would be a quick process. But maybe I didn't work with DPC, with Data Protection Commissioner, right?
Commission. It's it's not corporate in person. It's collective.
Okay. Yeah. Okay. So maybe they have a separate process for quick processing of such kind of requests. I hope so. And then Article 49, as Chris added, and then would be anonymization of personal information, getting this information in anonymized way and providing anonymous information back to the United States would be ideal. I would put it actually on the first place, right?
And it should be done together with contractual safeguards, as Christopher mentioned.
Yeah. Yeah, and the fourth point, of course, we are not insured against that. Maybe business can just accept the risk and to mitigate those, like a little bit limit and lessen those risks would be, you know, like creating the kind of collecting all those arguments for the case and proving the case that this is a single data transfer, which is my proposal, which is quite risky. Yeah, so we are speaking about risk acceptance, not complete.
Single but prolonged.
Yeah.
Very long dose of a transfer, sort of extending that, sort of bending the rules until they break kind of approach. Yeah, something people will always sort of look into. But I think just answering by leaving the question here a little bit, but like, of course, if this US company has any sort of means to install or use an already existing EU entity, maybe say, well, why not do EU marketing, not through our US company? Why not drive the whole EU marketing stuff from our EU business? So we have the EU entity, an EU controller. The transfer issue is cut out completely. We don't retransfer stuff to the US. We might give statistical data or something else to our sort of head of company in the US, but we will sort of run the whole EU marketing campaigns as a sort of contained solution in the EU itself. Might not work in our case, of course, but especially larger companies might have an EU sort of an EU entity, or even an EU representative, for example, already running. And in that case, you might think about sort of, is this really necessary to have the EU's company acting as a sole controller in that case, or do you can you give the controller kind of hat to your EU entity in that case? That might be a solution. Not really answering the question, of course, because this is like a restructuring kind of exercise, but just like that's always lies behind it, further considerations, of course.
Yeah, and another, if we are like stick to this case where we have no EU entity, then the question would be: do I really need European Union provider, European Union marketing provider? So maybe we will keep processing this information in the United States, use standard contractual clauses, make TIA and
supplemental measures
rules, at least because this road is clear, it's well written, it's quite straightforward path without.
And we don't need approval from the Data Protection Authority. It's time consuming.
Yeah, in that case, European Union is creating a negative stimulus. I mean, kind of, it punishes European Union businesses and prevents them from limits their competitiveness against American data processors. In fact, if
and as well as Chinese and from Middle East,
anyone outside European Union would be transfer to anyone would be possible if TIA result is positive, SCC is signed, and technical and organizational measures are implemented. Right?
I mean, look at the political dimension of that debate, of course. In that case already, sort of, I think if we were to hold that debate or this discussion, this kind of roundtable in somewhere close to Brussels, for example, I think the talk would be rather, look, the European Union is very strong in protecting individuals' rights, very strong in sort of safeguarding the protection of personal data. So it would sort of, it's kind of the other side of the medal or the coin kind of analogy we're having here. So of course you can see it from both ends at the end. But I think a smart solution, well thought through, well developed. Nothing too sort of spectacular, nothing that sort of tries to bend a bit too much. And again, looking at sort of how important is that in terms of like business reasons for you as a transfer, and if it's that important to your kind of core business, you should be able to sort of move and invest a certain amount of money and time to make that sort of safeguard transfer, at least a transfer that is defensible legally to a DPA. Of course, you can provide some remedy afterwards as well, or in the meantime if you find out that certain things have changed, but sort of put things into perspective a little bit. I think that's a very important point as well, apart from all the legal requirements that we've been sort of walking through here.
Absolutely. So thank you, Christopher. Thank you, Denis, for sharing your experience and helping two companies at least to find the solutions with international data transfers. Of course, it's not a legal advice. Please go to your attorney and hire us to investigate all the circumstances of data transfer. But it shows how creative data privacy professionals could be in finding the correct solution. So we named like 3 or 4 variants, 3 or 4 solutions for this tricky situation. And of course, it would be easier for everyone if European Union and European Commission would approve a new set of SCCs for the companies that whose processing is in the scope of the regulation because of the territorial scope of the Article 3 of the GDPR. But we are still waiting for that moment. Thank you, Chris, again. Thank you, Denis. And we'll move to the next topic, which is...
Thank you.
Have a great day. Bye.
Bye-bye. Which is very much related to the job Christopher does inside IPP, which is exam for CIPP and CIPM certifications. So many of you probably saw my my post in LinkedIn and Facebook asking, okay, guys, if somebody has recently taken CIPP and CIPM exam and wants to share his or her experience, please write me and we will add you to the panel. And I got quite a few messages, and a lot of professionals were ready to share their experience, and I'm very pleased to present a new panel that consists of Jamal Ahmed, Rima Musa, Tahir, Chodhari, sorry if I mispronounced your name. And we also expected one more participant. She will join our conversation in the middle. But right now, we will follow the following plan. We will start with introduction. We will speak about the benefits of the certification, whether it's worth its money and the time for preparation. Then we will go on to the tips of preparation and to experience that that our panelists had while passing the exam or preparing for this exam, and then we'll conclude with the overall summary of the recommendations that all our participants have for those who want to pursue this path. So please, guys, turn on your webcams and your mics. I invite you to take your seats in virtual room. So we'll now start with introduction. And the first person I would like to introduce himself is Jamal Ahmed. He has a very lengthy name in LinkedIn because a lot of certifications and titles. So please, Jamal, could you share your information about yourself? Probably many of our viewers know you. So, but for those who registered not from your LinkedIn, it would be quite useful.
Yes, thank you very much. And can I say what an absolute pleasure it is to be here. So thank you very much for the opportunity. My name is Jamal Ahmed, and I am the CEO and founder of Kasian Privacy Experts, an award-winning data privacy consultancy. And a few years ago, I found that my passion was actually in helping other people to become world-class privacy leaders. So I set up the Privacy Pros Academy, and we've been helping privacy professionals both pivot their careers, also transition to become world-class privacy leaders throughout the world. And it gives me such satisfaction in helping people to get certified, but to go beyond just getting certified and actually have the clarity, the confidence, and the credibility they need to show up and live their best professional lives and have that impact translate into their personal lives as well.
Mm-hmm. Great. Thank you, Jamal. Bilal, would you like to tell a bit about yourself?
Yes, hi. Also, great pleasure to be here. I've been doing data protection for about 10 years or so, a little longer, and I got the CIPP. In fact, I was originally going to do the CIPM today, and I was delighted when I saw your post, because that meant I could procrastinate and put the exam off yet another few days, which is probably quite a good thing. And I sort of recently did this because I'm trying to move sectors, and I need to kind of have some evidence that I know how to do the job that, in fact, I've been doing for 10 years.
Great. So I understood that you passed already CIPP exam, and you are preparing for CIPM, and you believe that it may help you with your shift to a new sphere, right?
Yeah, absolutely. I think that must be true. It just keeps on coming up in job descriptions. And because I've been working in not-for-profits for years, I've got most of my work through word of mouth. I'm now needing to come out of that kind of sector. And I suddenly find that I've gone back to just being completely unknown. So I need to have something that proves at a glance that I actually know something.
Great. Thank you, Bilal. Rima, would you like to join our discussion?
Hi, yes. So my name is Rima Musa. I am a former prosecutor from New York, and I am doing a career transition now. So that's where privacy comes into place. Back in January, I decided to start studying for the CIPP US and the CIPPE. And I actually attained both in February and March. So in the span of 2 months, I was able to get both the CIPP US and the CIPPE. I do plan on taking the CIPM soon, as I do believe that one really does set you apart after those 2 foundational certifications. So that's my goal in the next couple of months.
Great. So it's quite interesting example, because usually people pursue those certifications because they already take the place in in-house data privacy departments and need to prove their competence. But in your case, you are coming from the public sector, which is amazing. So this is the first time I hear the person taking 2 completely different jurisdictions, 2 completely different certifications, like European and American one. Was it hard to, combine all those 2 approaches?
Well, I didn't really combine them. I definitely studied for the US one first, which I thought was a lot easier than the European exam. And again, I think we, especially here in the US, we know how important the GDPR is. So, soon after that, I went in and I studied for the CIPPE. I think it was helpful to have studied for the CIPP US a month prior. It really definitely got me into study mode. I understood what the test would look like. I knew what was asked of me. So it was just learning the different types of legal structures, right? The US legal system functions so much differently than Europe. So that was the only, I think, difference between the 2 exams, is just learning a different system, a legal system. But other than that, I think the exam was, a little bit more difficult in that sense. But I was prepared based on the last exam I had taken.
Oh, I'm speaking to many professionals coming from continental Europe, and they say, okay, American CIPP exam is so hard, so many cases, so many laws, so many contradictory requirements. And I'm
you know
feeling...
what? But I actually thought the CIPPE, it was harder because there was a lot more to take in. It was a new legal system, like I said. But from my perspective, the European legal system was a little bit more straightforward. The US had a lot of different components to it. So in that sense, it was easier to follow, but a lot more content to consume than the US exam.
Okay, all right. So the next participant is Kristine Reyes. Marie, would you like to introduce yourself?
Sure. Hi, good afternoon to everybody and to esteemed fellow panelists. I am a lawyer coming from the jurisdiction of the Philippines. At present, I am in Germany taking my Master of Laws, with a concentration on data privacy and intellectual property law. Previous to taking up my master's, I was a lawyer in the Philippines as a senior associate in one of the biggest law firms in the Philippines. But my concentration then was corporate and commercial. So I did a lot of initial public offerings and due diligence, and that was my concentration. And then now I'm transitioning into tech and data privacy. So prior to my master's, I studied for the CIPPE last February. I passed it. And so now it opened my eyes and my perspective to European data privacy, which is very vast, very comprehensive, and very much grounded on the Charter of Fundamental Rights, which I think is a very good background and framework for data privacy. So yeah, I'm very glad to meet everybody and looking forward to our discussion.
When did you get your CIPP?
Last February.
Oh, so recent. Great. Tahir, would you like to join our discussion?
Hi, how you guys doing? Thank you very much for having me on. So I suppose a little bit about myself. My name is Tahir Chowdhury. I'm CIPPE and CIPM. I've got a bit of a different background than everyone. I've been in the restaurant industry since like the age of 10, then became a taxi driver. And 2 years ago, I mean, I never had a CV. I was never in a professional job. I didn't have the qualifications, the experience to get in data privacy. I never even applied for a job. But 2 years ago, I actually found Jamal, and he just enrolled into accelerator program, and within 2 months from knowing nothing about data privacy, I was able to get a holistic understanding and pass my CIPP exam before any of my other cohorts as well. And within 6 months from not having a professional career, I landed a career as data protection manager, which can take a number of years to get to, but I was able to do it within 6 months, which is a big achievement.
It's amazing. It's amazing. Wow, this is the story. Okay, that's great. So what are the benefits for CIPP exams actually? Jamal, why did you recommend Tahir to take CIPP?
Yeah, great question. So the main benefit of taking a professional exam is, number one, it demonstrates a certain level of competence. It shows that you know something. There's so many data privacy certifications out there. Some people have certified programs. There's BCS, there's the ISACA ones, there's lots of other ones. Some companies even have their own ones. And when I was starting off on my career many years ago, I wasted lots of time, lots of energy just getting certifications. First, I was like, I want to go for the cheapest ones or the free ones, your Coursera, Udemy stuff. But what I quickly realized was they didn't get me anywhere. Like I could have spent as much money as I wanted on all of these certifications, but what the industry wanted What would have helped me get interviews was making sure that I held the CIPP certification. So that's the main value of a CIPP certification, is it makes you marketable, because 80% of jobs, just like Bilal has identified, will ask as a minimum requirement for the CIPPE. And anyone that knows about the recruitment industry, you know, when recruiters are looking for roles, they will type in CIPPE on their client candidate systems or on LinkedIn. And if those letters don't come up next to your name, then guess what? They won't even consider you for the role. So it opens the door, first of all, to lots of privacy roles that you wouldn't otherwise be eligible for just because you don't have that certification. It is considered the gold standard by the industry and also by all employers across the world. And the reason for that is the CIPP is meant to test beyond can you regurgitate material. And most of the questions in the scenario are scenario-based, which means you have to take that knowledge and show that you actually know how to apply it in a context. So the businesses are now confident, this person doesn't know how to repeat GDPR or the articles, but they actually know how to apply it. So that is the main value of that, is number one, it opens up doors for you to either pivot your career into data privacy or to go for some of the higher up roles. And secondly, it gives you an opportunity to demonstrate, hey, I know my stuff. I don't just know how to talk the talk, but I just know how to walk the walk as well. And that is why people love to do the CIPP certifications. Everyone celebrates getting the CIPP certifications. And it all comes down to the effort that you put into it. The more effort you put into it, the more you'll get out of it. And somebody like Tahir, inspirational story, Uber driver to data privacy pro. Without those certifications, he wouldn't have got any of those interviews. Those certifications allow you to get yourself in front of a recruiter or a hiring manager to then show them what value you bring and all of the additional stuff that can say, hey, I want to come in and add value to your organization. And here's the reason why you can't afford not to have me. And the certification is kind of like the first path to opening the door to even have that opportunity to have a conversation to begin with.
Oh, so you say that recruiters know CIPPE. Do they know other certifications like ISACA's certification? I constantly forget its
the
name.
BCS is the other one.
Yeah.
So, I mean, look, here's the thing. Bilal, he if you look at his LinkedIn profile, you can tell he's a trainer for the BCS. So someone who's got 20 years of experience, wealth of experience in the public sector, dealing with some of the most challenging environments, local authorities, right? Delivering BCS training. Why is he spending time, spending money, spending energy, getting CIPP certified by the IAPP? It's because he's identified that's what the industry wants. And without that, you become almost irrelevant. So if you want to stay relevant, if you want to make sure that you're in the job market, if you want to have the best chances of being able to even apply and get selected for the first round interview for the roles, you need to make sure that you qualify. And therefore, you need the CIPP qualification as a minimum.
Bilal, do you agree? Do you confirm this?
I mean, yeah, to a great extent. I mean, I think certainly in the UK, if you're working in the public sector, then it's likely, because the public sector is relatively conservative about doing things like international data transfers, it's likely that the BCS qualification is enough. And you don't find very many people who are just working in those sectors within the health service, etc., that have anything other than the BCS qualification. But the moment you step outside of that, then yeah, I mean, most people look at the BCS qualification and think, well, what is that? Never really heard of it. It's mostly really the IAP qualifications that are globally recognized, and of course. Yeah. Even compared to 10 years ago, I mean, everybody, my plumber is global now. Somehow or the other, he just has data in mysterious places. So, yeah. So for that, I think it is the IAP. I think I would agree. The only place I would disagree with Jamal is he accidentally said that people enjoy doing the CIPPE. I don't think anybody enjoys it. I think he's gone far too far. Otherwise, absolutely agreement.
You need to speak to the 200 people that I train every year and see how much fun they have.
No, they must enjoy spending time with you, but nobody can possibly enjoy reading that textbook.
Rima, did you enjoy CIPP certification? I mean, exam.
Absolutely not. Absolutely not. I agree.
Look, here's the thing. The textbook was written by a bunch of lawyers, right? And lawyers do what lawyers do best. No disrespect to any lawyers watching. Is you're in your bubble. You're used to doing legalese, and you're always speaking with usually other lawyers. But as data privacy professionals, we have to interface with stakeholders, data subjects, regulators, other people. And the moment we start speaking legalese, or the moment we start regurgitating articles, we lose them, and they don't follow what we're saying, or they don't understand, or they feel like, okay, these guys are making me feel a little bit stupid. So when we read the textbook, especially if it's something that's new to you, data privacy laws is very new to you, it's very difficult to understand what is it that they're actually saying. And sometimes it feels like they hate people and they just want to make it as complicated and difficult as they want. And that's the reason I wrote the easy peasy guide to the GDPR, where if any of you have a look at it, it takes all of the legalese and complexity out, and it breaks it down in layman's terms. So even Bilal's plumber can actually understand what the GDPR is all about, and maybe even consider getting certified.
Oh, great.
The other thing I want to add on that is, if you listen to, so I did a podcast with Eduardo. He's the chap that's responsible for compiling the book. And if you go and listen to the podcast and you listen to the reasoning behind how they compiled the book, the reasoning behind how it was written, it actually becomes a little bit more enjoyable, because now you understand the context behind it, there's a little bit of meaning behind it, and it's not as painful as and excruciating as it otherwise might be.
During my classes, I use flowcharts to explain the logic, to show the metaphors, to connect those abstract ideas and terminology to some real life objects. For instance, if you rewind a bit this transmission, you will find the like traffic lights for international data transfer, and this diagram shows the rules of the article 44, 45, and 46 of the GDPR. With just single flow chart, it's much more easier. But the one input I would like to add to the point of why CIPP is my own personal experience. I started this consultancy and training business back in 2017, I believe, and at the time already. I was already working with data privacy, but it was a competitive advantage for my company, providing the training and consulting services to our clients. Say, okay, we have a trainer, we have a professional with CIPP credentials, and back then it was, I think it was January 2018, CIPP exam was still based on Directive 4695. So I had to wait until they update the questions of the exam to go with the first group of people who already passed a new format of the exam, because I didn't want to waste time on learning some national rules that come out of the Directive 4695. Though those rules, like 95% of them, migrated to the text of the GDPR. Yeah, so at the time it was a competitive advantage. As what I see now from what you say, Bilal, from what you say, Marie and Tahir, actually this is a precondition for a job. It's actually like prerequisite for getting into the hiring process. With so many things changed for these 5 years. Right. So anyone would add something to the benefits of the certification, or we can move to the next block?
I mean, the other thing, a lot of people in our industry suffer with self-doubt or imposter syndrome. So putting yourself through this process of saying, I'm going to put the effort in to demonstrate I actually know my stuff, it can help a lot of people alleviate that self-doubt, because, you know, you get validation and acknowledgement that, yes, you know what, you are a world-class privacy professional, you understand the GDPR, you understand how to apply it, and this is validation of your value that you bring to the table. So it can help overcome that self-doubt. It can increase your esteem. And of course, if you're certified, then it adds credibility. So sometimes people say, look, when I'm in the boardroom and I speak up, nobody wants to listen to me, or I don't feel like saying something. But now that I've got the certification, I feel a lot more confident, and people can see that, yes, this person knows what they're talking about. It's not just me saying it, but there's external validation at a world-class level that says, hey, this person is certified to an ISO standard or an ANSI standard, that they do actually know what they're talking about. So pay attention and listen out.
Great. Is there anyone here that has an examples of how certification has helped in your career already? Like, so you found a job. So we heard a success story from Tahir. I think that you wouldn't take this career as a data protection manager without the certification. Any other examples when certification is already working? Maybe Marie?
For me, I'm currently a full-time student, so I have not yet applied it in a particular job, but I am hoping that in addition to everything that I've learned in the master's degree and this CIPP, then it would be easier to comfortably find a suitable role that can, merge those data privacy education and use it in a practical way. So I guess some of our other participants can also share their experience and how it helped their career.
I'd say that, yeah, the training, the certification sort of gets you seen and gets you noticed. But to actually go through and get that professional career, you have to use from what you've learned from the training. Because if you just do the exam, yes, it's very good, but to get the actual underlying training that like how we learn, and you can talk the talk basically, and you can use those soft skills, you'll get hired immediately. But the CIPP certifications, the CIPM, CIPT, it's what gets you shown and it gives you credibility. That's the difference. I mean, if I didn't have this certification, I probably wouldn't even got a look at from any of the job prospects that I had. So yeah, this what helps you.
Yeah, and I just want to come in on that. Tahir is a very good point. So the certification, if you're looking to enhance your credibility and enhance your employability, it gets you noticed and it gets you in front of the individuals. But the challenge I see too many times is people see this as just something they have to do is to tick a box. And that's why you see so many people who are certified struggling to land roles or to successfully transition their careers. Yes, they have the certifications, but the challenge is oftentimes they've self-studied, which means that their understanding isn't thorough. So when the recruiters are talking to them or giving them a scenario or trying to ask them what their understanding is, all they can do is regurgitate a piece of text they've learned to memorize without any context, without any meaning, or without any applicability. And to truly pivot and to be able to convey the value you bring to the table, that you can actually solve those problems and you can get on with the stakeholders and get their buy-in, the business needs to know that you can take these challenges, make them into everyday language, and solve them in a language that everyone can understand. And that only comes from really knowing your subject matter, training with a mentor, spending time with like-minded people in the community who will help you to cover your gaps. And where you have some skills, you can also go and share and teach others. And you really learn a lot more by teaching other people. And that's one of the reasons why I spend so much time delivering the training, is because not only is it very satisfying, but the more questions I'm answering, the more problems I'm solving during the training, the more my consultancy game improves. And when I've got clients and people in the boardroom firing questions at me one at a time, I can just sit there and answer them all day without breaking a sweat. And that's what positions me in their mind as, whoa, this is the guy that we need. This is the guy that we need on our team. This is the guy we want to partner with. This is the person we want to train with. And when you go on the panels like this and you're live on stage and people are asking questions and everyone on the panel looks and nobody wants to answer it, and you go in there and not only do you answer the question, but you break it down in a way that everyone and their plumber can understand, then that's what makes you stand out. And that's exactly what we want to create at the Privacy Pros Academy, is world-class data privacy leaders. And we're all coming together to create a community because we have this vision that every woman, every man, and every child can enjoy their personal freedom wherever they go on this planet. And we can't do that by ourselves. That's why we have to make sure that there are well-educated people who have in-depth knowledge, people who can translate this stuff in every single company across the world.
Is CIPM also a prerequisite for getting hired, or it's not yet the case? Because CIPM is less frequent certification. I don't see much of this CIPM certification among young professionals. And what is the stage when people take this exam? So we heard from Rima that she's preparing for CIPM. Maybe somebody else is preparing for this managerial type of certification.
So I just took my CIPM on Friday and I passed it, which is actually done my training end of last year, but I just didn't have the time to read up and study and revise. So for the past month, I've got 3 steps basically on how you want to do this, and a lot of it is from what I've learned from Jamal. Is your mindset. You got to shift your mindset from a fixed to a growth mindset, an abundance. It's like a winning mindset. Once you've got that, then you need a mission. So that you've got the mindset, then you've got the mission, which is why is it you want to get a certification? What's your future goals? You need to have a goal, a plan. Like there's a saying that dreams come true if you have one. If you don't have a dream, you're not going anywhere. So you have to have that goal of what you want. And the third thing is you've got to take action. Most people will not take action. The difference between average and say amazing is just taking action. It's literally little bit at a time. You don't have to do much. Just every day, if you 10-15 minutes in a day, I swear you can learn. You can tell me to get into any role, any career, and I guarantee I can do it. Just how much time and effort it's going to take. That's all you need for any certification.
Thank you. I think you have a great talent of motivation speaker. So it's great.
Siarhei, to give you a little bit more context around the CIPM, you're right. It's CIPPE, most people do it, so I'd say 80%, and then you've got like the 20% that do CIPPE, and maybe like the 5% with like yourself and myself with the CIPT. So the way I describe it to my mentees is, look, the CIPPE is, imagine you're building a house. It's laying the bricks. You learn how to lay the bricks. You learn how to lay the bricks so that there's no problems. You can make great walls. And that's all of the detail. So the CIPP gives you the details, the DPIA, the lawful basis, the subject access rights, the international data transfers, the gap analysis, all of that stuff. But then it's not good just being able to lay the bricks. You're just a bricklayer. Who gets paid more, the bricklayer or the architect? The architect gets paid more. So you want to learn how to actually design the house, where the bricks are going to go. You want to think about, okay, which room is going to be smaller? Which room is going to be bigger? Which room is going to be next to each other? How much space do I need? How many floors do I need? And that is what we're talking about, the privacy program. How do we build a program for this specific company? And the CIPM gives you the architectural view, the bird's eye view. So yes, I'm going to design it like this. You already know how to lay the bricks. You understand that. So you know how to now be the architect and design the house, build the bricks. The only thing missing now is the plumbing and the water. And I say that's where the CIPT comes in, and you learn how the technology interfaces with the rest of it. And once you have all those things in place, you bring so much value to the table, and that's going to get you those more senior roles. That's going to get you the roles where you have to have that bird's eye view, where you're not just solving, running a process where you're doing a subject access request, doing a DPIA, doing your DPAs. You are actually solving problems organizationally, sometimes across jurisdictions, multinationally. And one of the great things about the CIPM is it's agnostic to any specific jurisdiction. And you learn the beauty of understanding what all of the different privacy laws have in common, and how you can then bring those efficiencies to create a world-class program that would help you to be compliant in all jurisdictions in which you operate in. So that's the value of the CIPM. If you want to have a higher level view, if you want to get into some of the more senior roles, then the CIPM is a must. And across Europe, one of the things that GDPR requires, Article 35, I think, somebody can quote me if I'm wrong there. I don't memorize article numbers. There's no need to have my guide. But it says the DPO must be an expert in data privacy law. So what does that actually mean? So we know people can go and get a law degree, but that doesn't actually mean they can do this stuff. But the industry says if you have CIPP plus CIPM, that qualifies you to be a DPO. And actually, if you look on the IAPP website, there's over 120 different trading partners, of which we are one. And a lot of people will say, hey, here's a package where you have the DPO certification. And basically, when you look at it, it's CIPP plus CIPM equals DPO certification. So if you actually want the role as a data protection officer, you have to demonstrate that you meet the requirements set out in the regulations, and getting a CIPP and a CIPM puts you in a great position to be able to apply for those roles and then bring the value to those businesses and serve.
Yeah. I see Bilal turned off his mic. So, Bilal, would you become an architect of privacy programs after getting CIPM? What is your feeling?
Well,
I think that you are still preparing for the exam, right? So
I'm gonna do it whenever I can just find a bit of time in the next few days, probably. I mean, I think, yeah, exactly as Jamal said, so many people do the CP, and I thought, well, I think the CIPM will certainly put me a little bit apart from like the big masses, and so I should do a further qualification. What I found really interesting, so when I did the CP, I didn't really learn anything. I just read the textbook and sort of learned a few bits and pieces. The first few chapters on the history, fascinating. There I learned lots. And in fact, I have to say, if you're never going to study this at all, just open it up and read the first few chapters of history. And just, you read so many judgments, you read so many things, and people are talking about things like trilogues, and you're trying to read all of these stupid articles on why the e-privacy directive has been held up, and you never really quite understand it. And then when you start reading about all of these political structures and the history, then you suddenly go, oh my God, that's what people have been talking about all of these years. And I kind of understood 70 or 80% of all of these articles. I never really understood enough, but I understood enough to get by. And I kind of felt, oh my God, I've been getting by. But the history stuff, absolutely fascinating. Doing a study for the CIPM has been really, really weird because I feel, because I've been running privacy programs for clients, and I kind of didn't really realize that some of the things I was doing had names. I never thought that these were things that I had invented because I'm not that clever, but I really didn't realize that these are the things. I just thought, oh yeah, I'm sure that's just what everyone does. And then there were lots of other kind of suggestions and different ways of looking at stuff. And a few times I kicked myself thinking, God, I should have done that other thing at the same time. I should have thought of it this way around. It would have just been much better. So CIPM has been really, really, really interesting because I've learned a lot. I think a lot of people go into CIPP kind of having some background in data protection. I mean, of course, a lot of people are completely new to it, but if you have a background in it, you won't learn that much from doing CIPP. The CIPM is really, really fascinating, and therefore I'm finding it much harder to learn because I'm really having to learn stuff. But I find that's going to be really, really beneficial. At the moment, I have no illusions about taking the CIPT. I just think that looks really, really painful. But I'm sure that Jamal will disagree and tell me how much fun it is.
Okay, so let's move to the next point of giving the tips and advice to our viewers. Right now, we have around 250 of them online in YouTube. Let me check the correct number. Oh, 245. So what would be the first tip from you, Jamal, on preparation for CIPP? Is it to go and purchase the official book or something else?
The first thing I would say is recognize why it is that you want to actually get this certification. Don't do it because someone's told you to get it. Don't because you think it's a good idea. Understand what it means to you. Because when you understand what it means to you, you will not procrastinate because you know what this means for you and in line with your goals, a little bit like what Tahe was saying. So find out why it is that you actually want to do this anyway and how that ties in line with your goals and what the results are going to be. Once you've got clarity on that, recognize that the CIPPE exam is all about the European Data Protection Regulation. So go and spend some time really understanding what this regulation is all about. The thing that frustrates me the most is when I speak to mentees or people who want to sign up and they want to do this stuff and they want to get enrolled in privacy and ask them, okay, how many times have you read the GDPR? How well do you understand it? And they say they haven't even looked at it. So that's the first thing I would say is start off by looking at the regulations. And when you look at the regulations, the CIPPE becomes a piece of cake because the CIPP is based on the regulations. It's just explaining it in different ways and how to apply it. So when you understand and appreciate the regulations, you've done 80% of the work already. The other 20% is like what Bilal was saying, just organizing where those things fit in your mind. And you realize, oh, that thing is actually a label. Oh, these articles that were talking about these rights, that's where responding to a subject access request comes in. Oh, this right to deletion, that comes from this article where this right was enshrined. So it's really appreciating and valuing the regulations. And the challenge with that is it's written in such a way where it's very difficult to comprehend and it can become very demotivating. So grab the easy peasy guide, jump into our community, listen to some of the podcasts, and just start joining in the conversations. Now you're familiar with it. Now you understand these languages, these terminologies. When you start preparing, everything will become easier. So I would say find a community, find a mentor, and put in place a program, a structured program, a proven program that works, that will keep you on track. When you have questions, you have hundreds of people that you can go and ask for. Some people will be ahead of you. Some people will be sharing the journey with you. Some people will know less than you, and it gives you a chance to help them. And when you help other people, they elevate you and push you up. So I would say, take it slow, make a plan, make sure you understand why you're doing it, read the regulations, make sure you understand it in a way that you can explain it to Gafur's Bilal's plumber. And when you know that you've got that level of confidence and grasp of the subject matter, then it's time to go and pursue the certification. Go and learn with a mentor. There's 120 training partners. The challenge with most of the training partners is you sign up for a 2-day program. Some lawyer that's hired in comes, reads some slides to you. It all goes over your head. You have a bigger headache than when you started, and you feel like, oh my gosh, how am I ever going to do this? That's why we take the easy peasy approach. We break it down into 4 or 5 days. We make it interactive. We make it fun. We use all of these personal things that you talk about. We use toolboxes. We use dinner parties. We use tea parties, all of these different examples just to make it relatable. And then it sticks, and then it becomes fun, and then it becomes something you're passionate about. And you get the value of what you're doing and why it matters. Everyone's talking about data is the new oil. Data is the new oil. Guess what? If data is the new oil, privacy is the currency. And the more value you bring, the more currency you have to play with, and the more value you can add, and you can get those top tier roles. And it's not just about getting those top tier roles for the reward. It's about what you're doing as an individual to leave a legacy, to mark an impact, to uphold that trust that all of those data subjects have trusted in whichever organizations you're working for. And that's where it becomes truly inspiring. And then understanding why you have to go and sit a 2.5-hour exam and answer 90 questions becomes irrelevant.
Yeah. And so back to the question about the first practical step about the exam. So the official book from CIPP, from IAPP, or the GDPR text. So I think Mary wrote as a preparation that you, Mary, started with the official, with the text itself, with the GDPR itself, right? And then you went through the reading the book. Did you start with the recitals or articles? It's my first question.
That's a good question, because I didn't actually read the recitals until after I took the CIPP.
Oh, okay, that's a good approach.
I read, and that's also my advice to anyone who wants to tackle the GDPR head on without knowing what the GDPR is all about. Take a look at the body of knowledge of IAPP. Take a look at how the GDPR is structured. The chapters and the articles have a flow. So once you are familiar with how it is, the structure of it all, and then dive into the provisions. And then do not expect to understand the entire GDPR on the first 15 articles, probably. Just take the time to read through everything and then understand how it all fits in together. Yeah. So one part is about the rights, but that's not enough. You have to know the security, you have to know the roles, you have to know the responsibilities of each player. So after that, and you have an idea, what I did was I read the text, the prescribed IAPP textbook, and then maybe I understood probably around 50% of it, made my own outline, read through my outline, read the book again, read the GDPR again, and then went through the sample exams of IAPP. So all that was a little bit frustrating, I have to be honest, but after the second reading, everything, not everything, but about 90% already made sense to me. And from there, I worked up the courage to get really prepared for the exam. So there was one thorough reading of my reviewer, one thorough reading of the GDPR again, and then not the book anymore, and then went through the exam with as much preparation as I could, but not the recitals. So there you go.
I see. So two times you read the GDPR text and then official book, and then made you probably worked with the body of knowledge, right? Because it's different from the book, and covered the topics that that were not covered by the book.
Yeah.
Okay, it's quite comprehensive approach, I would say. At my classes, I usually say to my students, read the first 50 articles of the regulation to understand what you as a business should do with the data. And then if you are about taking CIPP exam, read the next how many next 49 articles, right? And the best way of reading the recitals, actually never start reading GDPR with the recitals, because it's not a waste of time, but it's rather demotivating thing. The best way to read recitals is actually by following the article, opening the recitals that explain certain paragraph of the GDPR. For instance, you can see Article 3, the first paragraph about the context of activities, and you can see those two recitals that are relating to the notion of establishment and the notion of, not actually notion of context. Context would be reading the case, Google Spain case, which is in the case law section, and then switch to the next paragraph. And by reading the article text with the paragraph, with the recitals and maybe guidelines and case law, you would get the comprehensive picture of what is of all details that are embedded into this question. So I see that a number of participants turned on their cameras and microphones. Bilal, you was the first to turn on your mic, so probably something to add.
Yeah, no, I was going to say, all hats off to Marie. I mean, I'm not sure how I would approach it if I hadn't been doing data protection for years and years and years. So like I mean, the amount of work you've clearly done for this, epic. I just don't think I would have had the strength to do it. But if you are a reasonably seasoned practitioner, the way in which I did it was, you know, again, so much praise for the start of the textbook, the history stuff, which is something you just don't pick up on. The going chapter by chapter was really, really interesting. But for me, it was about, I skimmed the textbook very, very, very quickly, pulled out of it the few little bits and pieces I'd either kind of forgotten. What I was more interested in, I kind of wanted to use it as a learning exercise, was I started looking on GDPR Hub for relevant case law, because that's a lot more exciting than reading a textbook. It's the schadenfreude of who got what wrong, how badly did they get hit, what calamity befell them. That's always for me was much more exciting. For me, as a practitioner, it was much more interesting to think about how it affected my practice. So that's kind of how I thought about it, and I kind of then discovered I did know my way around almost all of it anyway. So I picked up a few bits and pieces, but I think for me it was how do you practically apply this stuff? And everyone learns differently. That's how it stuck in my brain. I think my sum total, other than the history stuff, the sum total of my notes was maybe 2 sides of A4, where I just scribbled down a few things which I'd sort of vaguely forgotten or hadn't thought about enough, and that was it. So as a practitioner, it was like, how does this apply to my practice? And that's what worked for me. But everyone does it differently. And yeah, again, really completely in awe of Marie. I really don't think, and this is one of the reasons I wouldn't do the CIPP US, is because just the utter faff of having to sit down and learn something that's completely alien to me. I'm just not even sure I would have the strength to approach it.
Yeah. Rima, would you like to add something on that? Comment on that?
Yeah, so I kind of want to piggyback off of Marie, you know, just on practical steps that I took. I think outlining is definitely important, and that's how I approached studying for each exam. You know, having gone to law school, I became a master at outlining. So, you know, I would go through each chapter, outline, and that's kind of how I approached it. I also use this website called privacy study group, which is great. It's free. It has a Facebook group where people who just took the exam share their experiences. They even share their own outlines. So if you want to, like, you know, connect with other people who just took it, who have some fresh outlines, and, you know, connect with them, I think that's also a great resource. In terms of outlining, I use the IPP. They have like this outline of what's important, you know, to address or to learn during your reading. So I use that outline, and I kind of just filled in those gaps, you know, as I'm reading. Also, the privacy study group gives you like a guide or updates on, you know, each exam. So that's good to know, and add into your outline as well. But, you know, I would agree with Marie. I think outline was probably the most important for me. You know, reading the articles and recitals, I think I would agree with Marie. I would do that after to really just understand. But in terms of passing the exam, I didn't really do that. I mean, I just, you know, went through the book. I read it, you know, front to back, and outlined every chapter, and then reviewed that. And I think that took me about 2 weeks. I think that's pretty reasonable. So it took me about 2 weeks to do that, to just do one read through, do an outline as I'm reading at the same time, you know, connect with this privacy study group, you know, check out other people's outlines, or, you know, any advice that they have if they just recently took the exam. But that would be my practical approach to studying and passing these exams. I'm not sure if the CIPM would be the same, but, you know, I would go off of what Jamal was saying earlier. I think the CIPM definitely gives you a different approach, even when, you know, interviewing for jobs. I think that you definitely learn how to put all those pieces together, you know, and to really prepare you for an exam, in my opinion, here in the US. I don't know what it's like in Europe, you know, interviewing for these positions, but I feel like the CIPM is probably more important here for me.
Wow, great, great point. What are the common mistakes do people make when they prepare for CIPP? Would you like to share yours, Bilal?
I mean, I'm sure I made lots of mistakes, but I'm also sure that I don't know what they were because I happened to pass. I don't really think I kind of dissected it, but I'm absolutely sure that I made lots of mistakes. I mean, again, I sort of didn't have to do this incredible job that Marie and Rima are describing because I'd been doing it for years. So I put in an incredibly small amount of effort into it. But that is a complete contrast to what I'm having to do with CIPM. I'm really having to sit down and learn words and terminology. And in fact, I'm going to steal some of their kind of methodology here. That's really instructive because when it came to the CIPP, I didn't really do that much work. I spent a lot of time thinking about problems I'd had with various things in the past. I mean, but I think the one thing I would advise everyone is figure out how you learn. Some people absolutely learn by writing and writing and writing. Some people learn by just making short diagrams. For some people, skimming and rereading and rereading. Rereading works. Some people just want to read once really deeply. Don't just copy whatever you think someone else thinks is best. You have to know how you learn, and everyone does it differently. But yeah, as I said, I'm sure I've made lots of mistakes. I could have done better, but I don't know what they were, and I haven't managed. I'll tell you if I failed at CIPM. There you are.
All right, then we'll schedule a second meeting. And
no, you're not supposed to say that.
I mean, you could share the hints for successful passing, right? So not only failing, but of course there is a saying that people who fail, they can teach you more than the people who pass successfully, because they really can they rethink what they did wrong, what they did right, and it's very unfortunate that no one of you, our dear viewers, who failed the exam, volunteered to take part in this session, because we would really get a lot from the people who failed the first attempt of the exam, because when speaking to them, for instance, one of my colleagues, she failed CIPM exam. She named so many things, very, very important things about preparations that I was never thinking of, and she helped me with my preparations for CIPT exam, because I was studying for that exam. Maria, would you like to add something to the possible setbacks and mistakes that could that people might make?
I want to add that going into the exam week, the week that I will be taking the exam, I was listening to the podcasts of Jamal, and it really dawned on me that in order to know that I was already prepared, I could explain these concepts to people who were asking me about, so what about these cookies? What about where does my data go? And how about, does it matter in this jurisdiction or the other? It meant to me that I could not just recite the articles, but actually explain it in everyday language. And that actually helps the concept stick in my head, so that during the exam period, or when I was taking the exam, I could remember the concepts as they are applied in practical terms. So I guess the most common mistake that I saw was that some people were approaching the CIPP as a purely academic exercise, wherein it's much more than that. It's really about applying it in a practical way into everyday setting. So that would be the approach that I would be suggesting to people who would be taking the CIPP. Don't just read the book or the law as it is, but to actually think about everyday examples of how privacy works in our daily life. So Jamal, thank you for that.
My pleasure.
Speaking about the examples, the things that Bilal said about the fines and the cases is very useful. So for those who are just attempting to take the exam, have a look at the enforcement tracker website, which lists all recent fines and cases, and gives a short explanation of every case. So by filtering, for instance, if you are reading Article 5 or Article 12, you could filter the fines and decisions based on the article and read through them. It really helps to understand, to map those abstract ideas, abstract knowledge to real case scenarios. And this database is constantly being updated, and I use it in my practice. For instance, when I'm not sure what is the risk my client takes when deciding whether to follow the rule or accept the risk, I usually use this website to show, okay, this is the violation you are considering, and it might be very costly for you, or it's very rarely detected. So this kind of information from world of supervisory authority and cases and fines and penalties really helps in preparation. So I would like to switch to the summary section of our panel discussion, and we'll try to summarize what we learned during this session. And please feel free to interrupt and add some points. So when speaking about the benefits of CIPP and CIPM, this is sometimes marketing differentiator, but in current times, it's a prerequisite for getting a job interview. And it's also a way to fight your imposter syndrome. I don't think that many of us doesn't have it. I do have, and before taking CIPT exam, I felt really uncomfortable with explaining some technical stuff. to IT guys in some department of my clients. And after taking it, I was more confident because you see, I'm a technologist. It's confirmed by IIPP. Anything else I should add to the benefits of this certification? Maybe I missed something.
I think one of the other things is it gives you a sense of accomplishment, like you've done it. It's not an easy exam, like by any means. Yes, people can pass,
self-esteem,
but yeah, it's that sense of accomplishment, and I think that's so important for us as individuals, because you put so much time, effort, and energy into it. Just one thing, I want to just go back a little bit. So look, I help hundreds of mentees every year across the world to get these certifications, and some of the common mistakes that I see them making is not planning and not preparing properly. So you should know when you want to sit the exam by, and you should have a learning plan or a study plan, and you should have a specific time, because it's all about consistency. The initial motivation, which is what Tahe was saying, is about the why do I want to do this? But then motivation disappears, and what leaves is discipline. And if you read Atomic Habits, or if you read Stephen Covey's 7 Habits of Highly Effective People, they all have the same message. What is the identity you want to adopt? So I want to be a great privacy professional. I want to be a great data protection officer. So if you want to achieve that goal, then what do you need to do? Then you need to have the expert knowledge. So it's not just about, hey, I'm just going to pass an exam, so I have a piece of paper that says something. It's no, I want to put everything into this so I can show up and be great and deliver great value and really protect the reputations of the businesses I'm going to work with. So it makes it easier. So understand why you're doing it, plan properly. If you fail to plan, then you're going to rush at the last minute. You're going to try and cram stuff in. It might have helped you with your university or whatever else you've done academically. Even if you pass, you still have to go and do this job. You have to look at people in the eye. People are going to ask you questions. What are you going to do? Hide behind them, hide behind emails, copy and paste articles and stuff that you've picked up somewhere? People want to hear from you. Like Marie was saying, the moment you realize that actually you can answer questions in easy everyday language using practical examples, that is what an expert is. It's being able to take out the complexity and simplify it. So focus on doing that. And the best way to do that, I think Rima was saying, is get yourself a nice community, a community of people who are at the same stage as you, some a little bit ahead, some a little bit behind. And one of the things Marie was explaining is about getting that context, getting that practical understanding. So if I'm only doing everything all by myself, I'm relying on what I know, I'm limited to my experience. I'm limited to my understanding. So how can I then convince myself that I am the best person to prepare me for this? And that's where going and finding professionals, finding mentors, training with someone who's done this, who has that experience, really helps. And that's where the fun comes in, Bilal. It's actually saying, oh yeah, this is all making sense. The pennies drop. I know how this stuff applies. And that's what helps people to really smash it on the first round. But it's not just about getting the exam, right? That should not be the goal. That should be one of the milestones of where you're actually gravitating towards. And if you understand why you're doing this in relation to the big goal, then it becomes effortless, and you become impatient on how quickly you want to go and get certified. And this effort that you need to put in, it becomes effortless because you're enjoying it, you're passionate about it, you understand how this is going to help you, how this is going to help the world, and how it's going to help you to show up as the best version of yourself.
Great addition, Jamal. Thanks. And when we follow this, recommendations, like understanding why we need the CIPP, then you could choose any path for preparation of the exam, depending on your type of on your individual preferences. Yes, we heard a lot about diagrams and breaking down concepts into the flow charts. Another approach would be communication. For instance, for myself, I learn a lot by speaking to others, discussing some things and finding solution together. Then might be reading through couple of times the official textbook and the GDPR text. It's also an option. It's a great option because you are basically get used and get acquainted with the source text yourself. Yeah, don't rush, plan, as Jamal just said, and remember, if you planned, you still have an option to postponing the exam like I think it's 48 hours. Before 48 hours, you still reschedule it. Anything else I missed? Oh, one important thing. It's one of the common questions. Sorry, we have just 2 minutes, but how to distribute the time for the questions during the exam? Do you have any methods? For instance, many of people try to calculate how many minutes and seconds
it's roughly 1.5 minutes per question. So here's my top tips that I give all of my mentees to smash it first time round, right? Always read the answers first. Read the answers first, then read the question. Otherwise, what you're going to do is read the question, read the answers, read the question, read the answers, read the question. The moment you read the answers first, you create a vacuum in your mind and your subconscious mind starts to fill it and it becomes easier. So read the answers first, go read the question. Straight away, you can eliminate 2 answers. That gives you 50-50. If you need to read the question again, then go back to it. And now when you come back to it, you've got 2 options. So one is going to be the right answer. The other is going to be a distractor. It optimizes your chances. The other thing I say, when you go into the exam center, they will give you a pencil and a piece of paper. Take the pencil and use it as a reading aid on the screen, because if you're trying to read the screen, your eyes will go up and down. If you've got anxiety, then it's going to be even harder to focus. But the moment you take that pencil and you just trace along the lines, you will make sure you don't miss the word, so you don't answer the wrong question, but it will increase your reading speed. And it means that you can confidently go ahead and really get through this exam. Take the break when they give you the break, enjoy the break, and during the break, give yourself positive affirmations. Remind yourself of all of the amazing things you've achieved in your life to get this far. Marie, Rima, you guys have told us about all of these law exams that you've done. That was much harder than doing a 2.5 hour, 90 question multiple choice answer, where the answer is there. You have to come up with the answer from your own mind for other things. So this thing you're about to see isn't the biggest thing, isn't the most difficult thing in your life. You've done amazing things. So go in as a winner, remind yourself you're a winner, and expect to get the result of a winner at the end of it.
I would add, don't spend too much time on each question. The testing system lets you flag a question that you want to come back to. So definitely go back to it at the end if you're unsure about it, but don't spend more than 1.5 minutes like Jamal mentioned. Flag it, go back to it. The test will let you answer it later. And if you're still unsure, do a process of elimination and then pick the best answer.
Yeah, it's a great advice. Great advice. So thanks a lot for sharing your experience, Rima, Marie, Jamal. Thanks, guys. So let's move to the next point of our program today, and let's learn what kind of tools we can use for better data minimization and purpose limitation in the processing activities. So I have an honor to introduce Tatiana Sivuha. Tatiana, you may also add something about your position and experience, but in the context of our previous discussion, as you can see from this slide, Tatiana started with CIPP certification and got this recognition by International Association of Privacy Professionals. Tatiana, did it help with your role of in-house privacy counsel?
So I would say most of the time when you apply for a new position, you can see that they ask you for CIPP certification. It's like a privilege to have you on board with CIPP certification. And most of the time, it's like a recognition that you have a deep understanding, systematic understanding of GDPR and privacy law. So I can say that probably hiddenly, it's helpful. But I think that I know a lot of people who don't have this certification, and they are also great people, great professionals, and they also hold a position like a head of privacy or DPO. So I can say that it depends. But if you would like to have it, definitely will add more value to your knowledge.
Great. So it's they must be very lucky, because we just were speaking that current HR recruiters really look for certain hints that the person is qualified for the position, and unfortunately they don't know many of the certifications except for CIPP. Yeah, let's go on with your topic, with your magic matrix. That would help us. I'll allow you to share your screen.
So, first of all, by the way of quick introduction, I'm Tatiana. I'm a certified privacy professional with almost 4 years of privacy experience in health tech, virtual reality, and ride-hailing industries. I hold CIPP and GDPR DPP certifications. I also privacy by design certified by the Data Privacy Office, and currently I'm a global privacy counsel at a leading ride-hailing company in Europe. So today I'm going to present an implementation matrix that highlights the integration of data minimization and purpose limitation principles into your processing activities. This matrix is not something that is obligatory under the GDPR. It was completely made up by myself. So actually it's just a helpful tool to help you. So yeah, to ensure your GDPR compliance with these principles, because we all grasp the importance and significance of data minimization, purpose limitation principles in upholding data protection standards and ensuring the privacy rights of individuals concerned. But no rule, no provision of the GDPR explicitly states how to comply with it. So actually the GDPR just states, so you should have adequate, relevant, and limited to what is necessary and have a purpose, but it doesn't say how we should understand and identify this purpose, because sometimes we even not clear with ourselves why we need a particular data for the particular purpose. And my goal today is share this practical framework designed to incorporate these principles into your organization workflow. And by understanding these metrics, by unfolding the magic of these metrics, you will definitely strike a balance between utilization of data for a particular specific, explicit, and legitimate purpose, and limit the amount of personal data that you use for your processing activity. So just let's get straight to our agenda. So first of all, I will touch upon the subject of data minimization and purpose limitation principles. So we are all on the same page, because I appreciate that a lot of technical people, a lot of marketing, probably people from other departments are presented on this call and this conference. So actually we should ensure that you understand what we're talking about. Then I will go to a little introduction to the matrix, so for you to understand what it serves, who fills it out, how it can help, recommend the tools for completing this matrix, because now you even don't understand what this matrix is and how to use it. So don't freak out, it will be clear for you in a couple of minutes. Then we will finalize our theory and deep dive into use cases, also completely made up, to unfold the matrix implementation for your specific case, so you can see how it actually works in reality. And then we will wrap it up with Q&A session. So I would appreciate you writing down your questions into the chat, and I will cover these questions at the end of the session, if we will not run out of time, because we are pushed for time today, 30 minutes for the presentation, so sorry for that. Okay. Organizational stuff is done, and let's get going to our first principle, purpose limitation principle. So the GDPR states that controllers should collect the data only for specified, explicit, and legitimate purpose, and not to process these data that is for the purpose that is incompatible with the initial purpose. Actually, it's not so clear, probably clear, but not in full. What specified and explicit mean is that the purpose should be clear and straightforward, and not in general for you. So you should be clear and open with yourself. Why do you need these data? Because if you will say, we need your name and email for providing services to you, it's not completely specific and straightforward, because no one will understand so which services you would like to provide and what we need to do with these. But if you state, we need to know your address to deliver the goods to your door, actually it means that you understand why they need your delivery address, just because they will use it for explicit and specific purpose. But if we talk about legitimate purpose, so I think that it's pretty clear. This purpose should have a legal ground and comply with data protection law, and also that is more important with other principles of law. Actually, it shouldn't be limited to data protection principles and GDPR itself. It should be extend it to any other laws that we have, any other acts. In Europe, for example, if we talk about GDPR, but if we talk about data protection law, because purpose limitation principle can be found in a lot of other privacy laws, so actually it also extends to other common laws that we have. So just to wrap up, to put it simply, what is the purpose limitation? Actually, it means that you should have a clear and explicit, straightforward purpose why you need to collect the data. So actually you decide, first of all, that you have a project, and probably you need data because you have a purpose. That's what you need to do. So, and define this explicit purpose as explicitly as possible, not in general. So, or to data minimization. So GDPR states that the data that you collect should be adequate, relevant, and limited to what is necessary. So adequate actually means that the data that you collect should be sufficient to properly fulfill your stated purpose. No more, no less, just enough. So it should be like something that you need, and without this data, you will not be able to fulfill your purpose. So it's pretty clear. What about relevant? So the data should have a relevant link to your purpose. What rational link? What this rational link means is that, for example, if you'd like to collect name for delivery, actually it's not so clear, just because why do you need name to deliver goods to your door? Actually, what you need is delivery address, and that's all. And then you switch the conversation in your head. Why do we need name? Probably just to verify that the right person got these goods. So actually the purpose is another purpose, to verify the recipient of these goods, not to deliver the goods. So actually, if you look into a rational link, you will completely understand that your purpose can be different just because you just looked into a rational link between the data and the purpose. So, over to limited to what is necessary. So it's also pretty simple and pretty clear that you don't hold more that you need for this purpose. Also, our example was the name and delivery address. So if you state that you have a purpose to deliver goods to the door, and you collect name and delivery address, actually name is the one that you hold more than you need for your purpose, because it's not necessary for your purpose. So that's what this principle encompasses. But to wrap it up, so data should be adequate, relevant, and limited to what is necessary. But if we talk about purpose should be specific, limited, and explicit. Sometimes people mix up purpose limitation and data minimization because they both refer you to intended purpose. And sometimes also in CIPP exam, you can be bothered by these answers because both purpose limitation principle contains in the answer something about purpose, and data minimization principle contains something about purpose, and you can be just confused. But what you should know is that if you talk about data minimization, it means that your data should be adequate and relevant and limited. But if you talk about purpose limitation, your purpose should be specific, explicit, and legitimate. So don't mix it up. So, and what I can say is that these two principles, they complement each other. In some way, it's not a question about the chicken and the egg. It's completely clear that firstly, you define your purpose, and then you build up your amount of data that you need for this purpose. If you will do this exercise backward, actually, it will cause a lot of problems for you, just because you just understand that you need amount of data, and then you try to choose a purpose. Actually, it means that you are not compliant with these principles. So that's it from the side of the theory of data minimization purpose limitation principle. But if we go to the matrix itself, so a little introduction to the matrix, that, as I said earlier, it's not a GDPR obligation for you. So actually, it's just a helpful tool to ensure your compliance with these principles. So it's completely up to you whether to have it in place or not. I just encourage you to try it out, just because, as you may see, the matrix logic is that who fills out this matrix is the team that would like to process new data or to start new processing. Actually, it means that your product engineering team, medical team, marketing team will need to have this conversation into their heads that will put on paper. So actually, it means that you provide them with the solution how to comply with data minimization and purpose limitation principles, and they try to complete this table, complete this matrix, and it will help you as a privacy counsel or a data protection officer to verify that you are compliant with data minimization and document it. It would be helpful for your other teams, just for them to understand and to talk to yourself why we need these data, why we need this amount of data, why we need this purpose. And it's also a helpful tool for them, not only for privacy counsel and data protection officer to be 100% compliant with the GDPR, you know. So how these metrics can help. So just take a look at this metric just so you understand how it's just looked, it looks like, but we will go back to these metrics in a couple of minutes. So how the metric can help, as I said, is just help you to identify your purpose and amount of data. Subsequently and consequently, it helps you to be compliant with data minimization purpose limitation principles. What tools I recommend to use for completing this matrix? As you see, this matrix is just a table. So any tool that allows you to, I don't know, to create a table and provide your answers and questions will be helpful. So actually, you can start with Excel file, with Word document, Notion, Miro, Figma, any tools that you would like to use. And I propose not to limit yourself to one tool, probably because most of the teams, for example, design team or marketing team, they are using Figma or Miro just because it's completely helpful for them. So you can allow them to use these tools, and then you can document it any way you would like to have it. I mean, privacy counsels, is because this metric should not be something that is red tape for your team, so that they don't want to be compliant with data minimization purpose limitation. Your role as the privacy counsel, for example, to provide a helpful tool for them to help you to be compliant with data minimization purpose limitation principles. And I recommend not be too restrictive in the ways of recommended tools, in the way of how to complete it. You can adopt these metrics to your organization needs and appetites and use it as you see appropriate, and not be too restrictive to my example, to my metrics, just because I provided this and it should be adjusted to your needs. So when to complete the matrix, you will definitely throw tomatoes on my scene if I say that every time you think of any new purposes, of any new processing activity, you need to complete this matrix. So that's the case because every time if you think of why don't we use all data for new purpose, why don't we create new project that will involve collection of personal data, every time you have these thoughts in your head, just complete this matrix. If we talk about product or engineering teams or marketing teams, if we talk about privacy counsel, every time you hear these thoughts, you should definitely provide this tool to your teams and introduce this tool to the wider company to follow these principles, because you will definitely reduce your fines or your non-compliance with these principles at your company. So this is the very metrics. I would say that the introduction and theory part are over. So actually we can go to use cases and dive deeper in this. Just a little disclaimer that these examples are completely made up, and any association with the real world use cases is accidental. So actually now we will unfold the metrics implementation. I will go to Mira board and present these for you. Based on the examples that I made up, so don't judge me in some way. So the first example is that we have an e-market delivering goods electronically and physically. So electronically, for example, it can be e-books, or physically, has decided to process personal data necessary for the purpose of delivery. So actually we have like the main purpose is delivery. So what we see here is that they defined the data they need, they define the main purpose, they define the level of importance of these data for fulfilling their purpose. So actually we can start from the understanding what this means. So purpose limitation. So here's two questions. One is the main purpose of this data being processed for. So you should define the main purpose. The yellow one means that probably you have another purpose and you should define if you can use this data for another purpose. When we see data sets, so it's clear, you just specify the categories of data that you would like to collect. When we make our way to data minimization, we see the level of importance, high, medium, and low. Actually, what does it mean? It means that purposes, so high level of importance means that purpose cannot be fulfilled without these data. So it's pretty clear. If we talk about medium, so data is supportive for the purpose, but it still can add value and you still can justify your collection. But in relation to low data, skipping this data will not affect the purpose. Actually, it's a red flag for you, because if you see that this table is completed, actually you should just carve it out from your processing activity, just because you will not be able to justify your processing. So what we see here, the main purpose is physical or electronic delivery of goods. And the company decided to collect name for this purpose. So when your team decide why they need the name, actually they see that courier will be able to deliver the goods without knowing the recipient name. And the team understands that, probably we either need to switch the purpose to another purpose or just keep collecting this data. And team decided to skip and switch to another purpose, that is verify the recipient of goods to the physical delivery. So actually this data is necessary. Most of the time it's also necessary under the legal obligations in a particular country, just to verify that goods are in the hands of the right recipient, especially if it's some kind of sensitive goods. So actually this data is really necessary. If we talk about electronic delivery of goods, so the team defined that they need email. So they defined that goods cannot be delivered without using email address. It's pretty clear. I can agree with it, because if you use this way of delivering goods electronically, so email is really necessary. It doesn't mean that you should provide your real email. You can create a one-time use email, and that would be completely okay. If we go down and see another purpose, physical or electronic delivery of goods, and we need passport data or country of residence. So passport data is the same as name, courier will be able to deliver the goods. So probably you need your passport data to verify the recipient of goods, not to deliver goods and services. But if we talk about country of residence, most of the time you will see in your delivery address form that you need to specify country of your residence. It can be confusing just because it doesn't depend on your country of residence. So you can ask to deliver goods not to your country of residence. You can be on vacation and asking for delivery of goods. And most of the time, country of residence means that the country where you are residing or the country where you have a residence permit. So actually it can be confusing, and people can specify their real country of residence where they hold residence permit. So actually, you should either rephrase your question, to specify home address, delivery address, or specify that country of residence is the country where you're currently residing. But in this case, team decided to collect country of residence. So actually, the country of residence is not relevant for delivery, especially for electronic delivery of goods. So this data is not necessary. And they didn't find any other purpose to collect this data, just because it's not necessary. And then if we go to our physical delivery of goods to the postal office, so you need to provide a home address. Actually, this address can help locate the most suitable postal office for you to pick up the goods. But actually, it's not the high level of importance, just because it just adds value. It can help you, but at the same time, you as a customer can choose any postal office that you would like goods to be delivered to. So actually, home address and specifying your home address is not the necessary thing. So just to wrap up this table, so actually what you can see is that, first of all, if you see that you have a main purpose, and then you see that for main purpose, the level of importance of data is low, actually it means that you should either switch your purpose to another purpose. But if you can't switch, so you understand that probably we don't have another purpose, actually it means that you should skip this column, this green column at all, just because it will be completely difficult to justify why you process these data. So if we talk about high and medium level of importance, high, it's completely clear. So you can use this data because you are compliant with your purpose limitation and data minimization principles. You documented your assessment. So actually this data is really necessary. But if we talk about medium, level of importance. It can be doable if you can justify to know, if you will document it properly. I mean, you will provide great example why you need this medium data and how it will add value to your purpose. Actually, you will be able to justify. But if the level, I would say, if the risk level of risk of your data is high, for example, it's a special categories of data or sensitive data, it will be difficult to justify even medium level of importance just because it's special categories of data or sensitive categories of data. So be attentive to these details and try to document it properly. So it should be not unambiguous, and it should be clear for you and for your team and for data protection authorities as well. So, but let's look into another example that is more complicated because it's related to medical team, I would say. And you can face a problem. That's when you're working with a medical team, you as a privacy counsel, you're not, for example, a medical staff, and it's difficult for you to understand if this data is adequate. And we can look into this example on how you can understand, just because the wording of particular columns will be helpful for you. So we have a mobile application that would like to process personal data to reveal early signs of Alzheimer's disease. So, and the team decided to collect certain data sets to identify an identified purpose and identify the level of importance of data for their purpose. So the first one is like, the first main goal is to identify declining memory function. It's one of the symptoms of Alzheimer's disease. And the team decided to collect memory performance tests. So actually, as is this one of the symptoms of the disease, these memory performance tests can help and necessary to identify one of the symptoms, to identify decline in memory function. So actually, this data is really necessary. But be attentive when you are working with the medical team, because there can be a lot of data sets and a lot of methods on how to identify decline in memory function, or how to reveal some signs. And if they identified, for example, that 3 out of 10 symptoms that as the main goal, probably you need to look into this, because you can see that, for example, you don't need to collect memory performance to identify a decline in memory function. You can collect less sensitive personal data, for example, to identify it. So that's why you should be attentive and always ask questions from different teams to understand if there is any ways to collect another set of data to fulfill this purpose. It's just because you see that probably this data is really of a high importance for this purpose, but there can be another data set that can fulfill your purpose and be less sensitive than this. So actually, the next purpose is, you see, cognitive assessment tests. If the team would like to use these tests to also identify a decline in memory function, it can add value inside, but it cannot serve as the tool to directly identify decline memory function. And as this example is example about special categories of data or sensitive data, it's completely difficult to justify that you use this data just to add value, just because it's special categories of data, and using these data to just add value, it's not enough to justify. So you should completely skip this table, this yellow column and this green column. So you don't even should be attentive to this. And what you can use, it's only the tables and columns that specify a high level of importance of this data. So actually, the last example is social media activity. So if you would like to detect potential cognitive impairments, for example, to track the timeline of the disease, how the disease is progressing, and you would like to see social media activities, how user posted any social media interactions, probably to understand this decline and the timeline. So you can see that it can add value, and it's completely true, it can add value, but it can't identify or state that you have a decline in memory function just because it's social media activity. But it's at the same time, social media activity is not special categories of data, and you can use these as so you can use these data to add value just because it's not special category of data. So that's completely okay, but be attentive to these details. and be attentive to the purpose, to the data set that your team would like to use. And as a privacy counsel, I mean, and if we talk about product teams, engineering, marketing teams, medical teams, and so on and so forth, you should be attentive to what you write and how you justify it, because you can it can be necessary for your purpose. But if you say something that is not provable, so it can be complicated for you to justify it even before your privacy counsel, not regardless of data protection authority. So just to wrap up, that's all for this magic matrix. You can adopt it as you would like. It presents just a table with questions and answers. You need to evaluate the level of importance of each data. You should completely skip a column when the level of importance is low, because it's just completely difficult to justify your purpose. If you have a special categories of data or sensitive data, you cannot use medium or low columns, just because it's a special categories of data and they possess more threats to your users and to your customers or data subjects. If you have less sensitive and not special categories of data, you can use column medium, just because you can justify this and the level of risk of this data is not so high. So that's all from my side. If we have any questions, we may discuss them.
Yeah. Before I check the questions in YouTube, I have a practical advice. Not advice, question. First of all, thanks for great rethinking of this data minimization and data purpose limitation principles, because it's hard to operationalize them except for those, logical kind of questions to yourself about whether the data is necessary, whether it's sufficient, or what kind of information could be used for another purposes, right? So you basically operationalize one of the most abstract, one of two most abstract principles in the GDPR. Thanks a lot for that. But for instance, during the process of collecting information about processing activities, which is called ROPA, when filling the ROPA, how could we integrate it into the ROPA? With what kind of tool? Would it be Excel sheet, spreadsheet, with all those columns, or we always should use Mira and to visualize it for stakeholders? How do you do it on practice if you apply your own methodology?
So most of the time, if the company is scaling and it's a big company, you can have automated tools and you can integrate these metrics into automated tools. And when some team completes this table, you will have an automatic trigger to change your ROPA. But at the same time, if the company is not big or is not using any automated tools, it completely depends on how it's best fit your needs. For example, if you use Excel file, you can then transfer it to your ROPA, or to have like, I don't know, just to do it manually. It's not a good idea, but it is what it is. We use what we have. If we use Notion, there also can be a practical solution, because Notion have some kind of functionality when you can also trigger one changes in one table to changes in another table. So also think of this automated tool. Thanks for raising this question, because it's a helpful tool to for ROPA as well, because you will just ensure that all teams complete this matrix, they complete all the necessary information, and at least purposes of data processing and data categories will be in your ROPA, or will be in your, for example, a good background, a good ground for your privacy notice, for example. So it's a good idea, and try to automate it as much as possible, not be too restrictive to it, and it would help you a lot.
Mm-hmm. All right, so I understood that the best way for us, for instance, since we are a consulting company that is making ROPA for our clients in Notion SO, which is a tool that you just mentioned, would be building this matrix in Notion, since we have already this tool implemented and templates ready to be exported to our clients. Great. Thank you, Tatiana. I see the comments. These are no questions. Somebody writes that you are the best, the best coach ever. Yeah, that's great. So, guys, I address to our viewers. If you have questions about the matrix, please send them now. We'll distribute this presentation to all of you if you registered. Don't forget to subscribe to our channel, because in this YouTube channel you'll get the edited version of this conference. You would see videos appearing in this channel, so you could see those videos edited nicely and you could use them for your practice. So please subscribe, hit this like button, and write the questions to Tatiana. Otherwise, the best coach ever would miss her questions. Okay.
So if we will now have any questions, so we will definitely address. I mean, if we will have questions after my presentation, I can address them after my presentation if we have this opportunity to do so.
Yeah. Just to add something new, I know you are a trainer, you are a coach, you also train people for different types of certifications. So could you tell a bit about the approach you are taking when training people, and as a summary or some advertisement, you can sign up for Tatiana's training online by going to dataprivacyoffice.eu. There you could find our courses, our training courses. So both me and Tatiana deliver them, and there are some other trainers, including Louis-Philippe, who just joined our conversation because his speech will be the next. So if you feel that you can take something from us, like some knowledge, some experience, or some approaches, please go ahead and leave your applications there. You would sign up. You could sign up to any of the courses, and then managers would contact you, ask, and probably they will check what is the best option, the training option for you. Then they would suggest either Tatiana's course or my course or some other courses, including the course on international data transfer, depending on your circumstances. Okay, back to you, Tatiana. How do you teach your students?
So I have an attitude and approach that the course should be as practical as possible, just because there is a lot of theory in GDPR and in any guidelines. So guidelines, they are also mostly practical, but at the same time, when you're working with people who doesn't have experience, people who don't have experience, or probably who have a little time of experience, it's best suited for them to provide practical examples and provide them with cases and try to work on cases. Sometimes I don't open even this book. I just see what's the agenda for today's, for example, meeting in our session, but I don't follow this book just because I would like them to know as much as possible. So if I prepare, so I'm also preparing to these sessions for 6 to 7 hours, just because I should be able to provide any practical advice and answer any question that they have, and they can have different questions. Sometimes even people with a lot of experience can't answer these questions. And when I read through the materials, I understand that sometimes some questions can pop up, and I try to find answers to these questions and provide as much as possible in relation to the practical advice. So sometimes we also discuss how it works in practice. It's not necessary for CIPP exam, because it's is like in general, it mostly covers theory, but at the same time, if they know how it works inside out, how it works in practice, and we share our practical experience, they understand how it works. The second advice I can provide is that your course should be systematic. So actually it means if you present some theme, just you need to summarize it in a systematic way. So for people to understand 1, 2, 3, so the key message that they can take away from your session, from your lesson. Because sometimes they can understand each single part, but they can't understand why we need this and when to use this. So actually, that's the main point, that you need to ensure that they understand when to use this. If you see that someone from your team, or I mean from your mentees, can't understand some concept, you can directly contact him and ask and ensure that this person understands all of this, and probably to fill his gaps, provide more guidelines to them. And thirdly, it's just to not to limit yourself to only to the preparation book provided by EAP. You should also read guidelines and provide them more guidelines to read. So if they would like to read, they will read. If not, they will not. But at least you should have this option and provide as much as possible, just because you as a privacy professional knows where to find it and which guidelines are mostly relevant for the exam, for their practical experience. So you should provide it, and it's up to them to read it or not.
Great. Thank you, Tatiana. I got one more comment, and it's not a question again. So no questions, just admiration. Thanks a lot for sharing this innovative model on the matrix. I need to contact you to add this matrix to data privacy professional course myself, because it really makes things simpler, and I would say we could and with this matrix we could build a process. Just not mental activity somewhere in the mind of data privacy professional. This is a flow and logic, what I like most about your approach. So I would be happy if you allow me to reuse the matrix in our data privacy professional course. And certainly, of course, CIPP quite restrictive about the program of CIPP training, but we as official provider of CIPP certification preparation training, we could probably discuss with them to include this additional material to the course itself. I think Jack Tinker, who is our trainer, would be happy to do that.
Okay, thank you a lot. So take care. See you. Bye.
Bye bye. Let's move on to the next topic, which is very closely related to IT startups, because right now we'll be speaking about how to build privacy, how to embed privacy by design into the products of startups. So Louis-Philippe Breton, who is a PhD trained, I think, in France, right, and in Canada and in Switzerland, and a lecturer with a great experience, and my colleague, fellow data privacy consultant, would share with you those tips. So please go ahead, Louis-Philippe, to share your screen.
I'll just switch here. I say and be sharing soon.
Wonderful, we can see it. Yeah,
I think it works now. Okay.
Classical startup. I mean, the atmosphere of startup. Yeah.
Yeah, it's the
People
atmosphere.
working at home at the apartment somewhere. Yeah.
Yeah, it's already the way we almost all work. from home
Yeah.
in a calm environment. So
Yes.
good afternoon, everyone, and thank you, Siarhei, for the introduction. I'm thrilled to be here today to share with you practical tips for building privacy into product design. As a data protection consultant and a practicing lawyer, I've seen firsthand the importance of privacy in the life of a startup. Perhaps Tom Fishburne humor best sums up how challenging web and app design can be. On the one hand, you need to convey information to your visitors about your products and your services. And on the other hand, you need to comply with legal obligations and respect personal data. If not well designed, you could easily end up, as in Fishburne's cartoon, losing potential customers. They may be scared away by the fear of sharing too much personal information. According to a recent Pew Research Center survey, 81% of US consumers believe the potential risks of collecting information about them outweigh the benefits they might expect. That is precisely our topic today. Whoops, too fast. That's precisely our topic today, how building privacy into product design can be a competitive advantage in the battle for consumers' trust. A concept was developed in Canada in the 90s to address the challenges of information and technology and communication technologies and their impact on people's personal lives. The term privacy by design was coined by Anne Cavoukian, the former Information and Privacy Commissioner of Ontario. She understood that privacy could not be guaranteed solely by complying with a legal framework. Organizations, she believed, could benefit from making privacy their default mode of operation. It should be an essential element of a startup's success, not just a legal obligation. The main objectives of this privacy by design concept are twofold. One concerns the data subjects, the persons whose data are collected and processed, and the other one relates to the company that processes the data. The first objective is to ensure the privacy of individuals and to give them control over their personal information. And the second one is for organizations to gain a sustainable competitive advantage. In 2010, the Office of the Privacy Commissioner of Canada this time proposed introducing the concept of privacy by design into Canadian law. It argued that since the most innovative actor in the digital scene were small and medium enterprises, in other words, startups, the topic of today, privacy should be considered at the design stage of application developments by individual designers and developers. Unfortunately, privacy by design was never incorporated directly into the Canadian law, but it was years later into the General Data Protection Regulation, the GDPR. So let's now take a step back and try to understand what privacy by design means and how it is relevant to startups. Privacy by design is a set of good privacy practices that should be embedded in the design specifications of technologies, business practices, and physical infrastructures. It isn't just a concept, it's a philosophy that should permeate every aspect of your startup's DNA. It's about building privacy into the very foundation of your product design, ensuring that privacy becomes an integral part of the user experience. There are 7 foundational principles the basic foundational principles of privacy by design, and they are at the heart of this concept. We will take time to explain them and give concrete examples on how startups can implement them. The first one, as you see on the screen, the first one states that you should be proactive, not reactive. Privacy shouldn't be treated as an afterthought. Startups should integrate privacy considerations from the very beginning of the product design process. The goal is to prevent privacy risks from occurring, not offering remedies once they materialize. One of the best examples I know of is Proton Mail. The Swiss-based company, which provides mail, calendar, drive, and VPN services, was founded around this idea, this very idea of privacy. They designed their products right from the start to offer end-to-end encryption to protect their users' communication and data. The second principle is privacy as the default setting. Startups must choose default settings that are the most favorable to their users' privacy in IT systems, websites, applications, or software, and even in their business practices. Users' privacy should be automatically protected. Individuals shouldn't have to change the settings to protect their privacy. It should be set by default to the maximum privacy protection. No action on their part should be required to achieve that privacy protection. Clear and prominent privacy settings that allow users to customize their privacy experience should always also be available. Signal, one of the most secure messaging apps on the market, sets privacy as a default for all its users. All conversations are end-to-end encrypted by default, ensuring that users' messages remain private and secure without any action on their part. They have also structured their company as a non-profit to avoid the pressure of market forces. This allows their application, Signal application, to be free of ads and trackers. You see how they implemented privacy by design even in their own concept of their business. The third principle is privacy embedded into design. Privacy should be the baseline of your product design in every feature and every possible interaction with your users. It shouldn't be a feature added after the product or interface has been designed. Privacy should harmonize with the overall user experience and be part of the architecture right away at the time of conception. Privacy consideration should be integrated into the product development lifecycle, including privacy reviews at every stage. DuckDuckGo, a lesser-known search engine, is a good example of privacy embedded into the design. It is conceived by default not to collect or store any personal data and to block every third-party trackers. The fourth out of seven principle is called full functionality. Embedding privacy into the design doesn't mean that privacy will overshadow the functionality of your product. Privacy by design should allow you to offer robust features and services as you originally intended, while safeguarding users' personal information. The equation shouldn't be privacy versus your needs as a startup. There shouldn't be a dichotomy between preserving the user's personal data and maintaining the functionality they expect and that you designed in your product. The fifth principle is end-to-end security. Privacy should be preserved throughout the entire life cycle of the data, from their collection to their destruction. Your product design should include strong safeguards against unauthorized access, data breaches, and other security risks. And they should be maintained on an ongoing basis. Privacy by design, therefore involves the secure management of information throughout its whole life cycle. The sixth and penultimate principle is visibility and transparency. Startups must be transparent about their data practices. They should inform their users about how their data are collected, used, and shared. Cookie and privacy notices must be user-friendly, free of legal jargon, and easily accessible. Users have to be confident that their data are being processed according to the stated policies. And Zuzo, a Canadian company that sells privacy compliance products, has one of the cleanest privacy policies I've ever seen. It is well structured, easy to navigate, and very short. Maybe a little bit too short for the GDPR requirements, but it's a good example of designing the privacy policy to make it accessible to your public. They have also implemented a simple way to contact them and make a data request with a simple click of a button. The seventh and last principle could be the first. Companies should respect their users. We've already mentioned it, but this respect will in turn be a strong asset for a startup, as it will earn the trust of its users. Privacy is a key part of your relationship with your customers. It's about creating products and services that not only meet legal requirements, but also inspire trust, loyalty, and confidence in your brand. You should communicate regularly with users about your privacy practices, including any updates or changes to your policies. And you should be responsive to users' inquiries and requests regarding their own personal data. Now that we've seen the essential principles of privacy by design, let's learn how to implement them. We've laid down so far the foundations and reviewed the principles and origin of privacy by design. It's time to shift our attention to data minimization. Maybe you ask yourself, why tackle such a topic when talking about building privacy into product design? Because it's one of the key requirements of the provision on privacy by design in the GDPR, the European regulation. Article 25 states that the data minimization principle provided for in Article 5 should be fully respected in the process of complying with this Article 25 and the concept of privacy by design. Processed personal data must be adequate, relevant, and limited to what is necessary in relation to the purposes for which they are processed. We won't go into the details of this principle, as Tatiana has already talked about it earlier, just before me. But let's mention some important aspects. First, you need to understand the specific needs for your startup. Ask yourself, what data is really necessary for the product or my service? You should collect, as the previous speaker already explained, only data that directly support your business objectives while minimizing the collection of unnecessary and excessive information. It is important to ask yourself these questions before starting designing your product or service, because the data minimization principle has a direct impact on design choices. For example, you should provide users only essential feeds to collect the data you really need. On a website, if you show multiple fields with different data, your user may think that you will have to fill all these fields and you will collect more data than necessary. That's why it's so important to think about it before designing your product. You will make available only the fields that will collect the data that you need for the purpose, the stated purpose. Once you've been through this process, you have to conduct periodic data audits to review the data you collect and store, and ask yourself again the questions we've just mentioned. Assess regularly whether you still need specific data, if it's no longer necessary for the stated purpose, or if the purpose has changed over time, simply stop collecting them. As a corollary to data minimization, startups should maintain a clear retention policy. Determine how long you need to retain data for legitimate purposes and establish processes for securely deleting data that are no longer necessary. Collecting and retaining excessive data can pose significant privacy risk for a startup. For example, retaining data longer than necessary increases the risk of unauthorized access or data breaches.
Yeah, I can. Sorry for interrupting. We have this requirements on one side, and startups that in most cases won't live long, because like I think only every 10th startup exists after 2 years of functioning. So basically most of the startups would end on the MVP stage or quite early. Yeah, and even before they started to collect personal information. And this is a dilemma that we face when working with startups. The dilemma of, okay, building and designing the process right now with the privacy in mind, that would mean like 2-3 more months of development and you know, attracting privacy professionals or some kind of other specialists that would help with privacy functionality, or launching the product first, and then kind of solving those issues that are embedded into the software. And I have 2 examples on that. In one example, the company that launched its product wasn't doing this privacy assessment, and were not minimizing information. And at the launch, I think it was 3rd or 4th week of the launch, they got a data subject access request that they were not able to execute, and they got a complaint to the supervisory authority. And the product, which was hard to amend, hard to change, because the design would forbid it was forbiddingly expensive for the company to redesign its product, because there was scrapping of LinkedIn profiles on one stage. On another stage, they put some information into blockchain, including personal information, and technology was not allowing them to, for instance, delete the data. It's a bad example, and I have even worse example when the product never hit the market, but a substantial amount of efforts and resources was put into privacy compliance. So why the second example is worse? Because it's kind of it might be a good, if people know this example, they would think twice before, hiring privacy professionals and implementing privacy measures, because this kind of demotivates those businesses that do follow the right and correct steps. So what would be the best kind of compromise on this stage, of designing the product? What would be, middle ground for businesses at the early stage of their existence to implement the privacy by design principles? Because of course, the complete compliance would cost them much time. And might be not really
it could
reasonable.
be difficult. Yeah, it could be unreasonable to try to comply completely to all the requirements of data protection, especially if you launch your company on an international stage and you want to comply with different legislation around the world. It would be very difficult, but still you have to put into balance, exactly like you said. You could have examples where if you don't take into account some specific legislation, some specific provisions while designing your product, it could be very complicated afterwards to launch your product, or you can launch your product and, as you said, you just have to scrape it and think about a new product right from start. That's the logic of this principle that started in Canada of privacy by design. It addressed, as the Privacy Commissioner of Canada mentioned, especially startups, because they are small and medium-sized enterprises. And in this context, it's easier to work with 1, 2, or a reduced team from 2 to 5 persons to work directly at the launch of before launching the product, at the time of developing it, to try to comply, at least to have in mind the requirements of data protection. I have one example in mind: the new Indiana Consumer Protection Act in the US use precise geolocation data in the law that will be effective next year in July in 2024. If you use in your app precise geolocation data, it becomes sensitive data. So if you don't think about this aspect right at the designing time, you will have to redesign completely or partly your application. And you have direct implications, because you will be, if you use precise geolocation data that refers to a specific location of a person within a radius of 1,750 feet, these data will become sensitive data, and you won't be able to process them, except if you have the consent of the consumer and you previously conducted a data protection impact assessment. So that brings me to the last point I wanted to talk about today. this data protection impact assessment, because that is where you can, before starting your project, find the gaps in the project, understand the requirements of the regulation you will be facing, and design your project keeping in mind that concept of privacy by design. So when you start a new innovation, it requires planning. Of course, as you mentioned, sorry, it's complicated when you just start your startup company. You don't have, and we have all in our practice this example of companies that comes to us at the very early stage of developing their product, and they say, yes, I want to comply with the GDPR or other national legislation, but I don't have that much money and I don't have that much time also to comply with it. Maybe if you use different tools to conduct a privacy impact assessment, even if it's just a basic questioning at the beginning, using online available tools, templates, or different software, it can help you have a first understanding of what will come regarding privacy and data protection laws. If we think about this Indiana example that I just mentioned, it's way easier to study the impact of its provisions before starting the project than to change the design after. Maybe I can show this example of the tech GDPR canvas to start understanding the processing in your company and the data that you process. A tool like that can be interesting as a starting point to learn more about the processing in your company, to help you gather the necessary information to complete a PIA shortly thereafter. It's a very simple version of what we call in the profession ROPA, record of processing activities. I think that it's accessible to startups, to developers, to fill this and to have just the first understanding, the first picture of the processing in your company. And then with this information, you can conduct by yourself or with the help of a professional, a privacy professional, a PIA, a complete PIA. And one of the two models that we use is the CNILS, Privacy Impact Assessment Software, and the ICO's template that you're familiar with.
Yeah. So universal advice to the startup: start with DPIA for the most risky part of your system or the whole system, and it would really show you what are the parts inside the system that should be rethought or redesigned, because before it's much easier to correct it before the launch, before the programming stage. Otherwise, it would be too late. So the next slide is about ICO template, right? So
yeah, this is an example of a good template. It doesn't really matter actually what template you use. The most important thing is the questions in the template itself. Most of the templates will ask the same kind of questions. It depends, some of them, like this one from the ICO, the UK ICO, the Information Commissioner. It's really simple, it's really short, and it asks very straightforward question that could be more or less easy to answer if you made that first step of making a portrait of the data that you intend to collect. And of course, if you need help, you can ask privacy professionals, but it's something, using these templates and these these questions, can help you understand by yourself first if you need help, can you help you understand the complexity of your project, and if it will be challenging to comply with data protection in the future. And of course, we see it in the practice that most people will come after the development phase is way in the process or is even over. Another example is the CNIL's PIA software, that it's way more complex, that asks a lot more questions and may be challenging to fill by a developer or startup owner. It may be challenging, but it's more complete. It gives you a more complete analysis and more detailed evaluation.
Thank you, Louis-Philippe, for sharing this important thoughts on and templates. We'll distribute the presentation of yours, the slides of yours among the participants. Those who subscribe to our YouTube channel would get the shortened and edited version of every single presentation that we had today. So please make sure that you subscribe to the YouTube channel that you are watching this video at and like the video. Besides, I must emphasize that you have right now you have a unique opportunity to ask the questions in the chat box, the questions about AI and machine learning implement and with regard to privacy, because we have one of the leading experts in AI regulation and AI technologies implication on data protection. So thank you, Louis-Philippe, and I'm turning floor over to Denis, who already spoke today at 2 occasions at the Consultation for International Data Transfers and at the presentation of the rules for international data transfers. So this format, the format of today's consultations, consultation is actually participants asking the questions and we are answering those questions. Some of the participants asked the questions in next to YouTube video, and this is a straightforward way of getting the complete and the quickest answer. We were pretty much sure that not many of the privacy professionals are working with AI and machine learning right away, and we had to go to our clients, data privacy office clients, and asked those that implement implement AI and collect the questions. So we collected some questions and I posted those questions in Miro so we can walk through those questions in Miro. Besides, we got one not AI related question, but related rather to international data transfer. So in case we don't have many questions from the audience, then we would switch to the questions of the EU representative and Article 27 of the GDPR. But let's start with the questions that we prepared, because so far I don't see questions in YouTube. But as soon as we get ones, we would switch to the YouTube questions because they are higher priority for us, since we can, our clients can afford speaking to us almost every day, right? But YouTube audience doesn't have this doesn't have this privilege. So let's move to the to our action plan for compliance. So right now we passed through the question of identifiability of personal data, looked at the matrix that could be used to operationalize data minimization and purpose limitation. We just had a presentation about designing products with privacy in mind. We have a great presentation about the risks and class actions. And right now we are at the stage of consultation, like express consultation for companies that begin to integrate AI and machine learning into their products and operations. And to be fair, I didn't show those questions that we collected to Denis. So and I didn't read them myself to make sure that we have a level play field. And right now we will try to break down those questions into elements, and make some assumptions and try to give the consultation. So the first case, our company aims to integrate NI chart model into their products. We are unsure if the start chat action implies the user consent for the use of their data for AI training. Is consent even necessary, or is it a contractual obligation? Additionally, if the product specializes in health topic, how must we implement consent to process personal data? What other legal requirements must be compliant with? So a lot of questions in this case.
You should split it out, divide this question into several ones.
Yeah. What parts do you propose? What parts for splitting?
I think that we should start from the question of legal grounds, legitimate grounds for using personal data to create AI for purposes of AI training.
Yeah. May I propose also to add the question of the purpose? So we need to. I think before legal grounds, discussing the legal grounds, we need to
define the purpose.
The purposes. And I think at least here we can see two purposes. And so we would end up with two legal grounds for different purposes. Because from the question I see this training AI is one purpose. Not the first purpose, because usually the chat is used to, I think, what? To get a medical.
Yeah, I think that the first question should be: does privacy legislation apply to this process of AI training at all? Because many of AI developers and companies who use AI solutions or develop AI solutions are not aware about the cases when privacy legislation covers the issues of AI implication or maybe creation of AI models.
Yeah. Though I know the answer to this question, but I must ask it so we kind of lay down the ground for the audience. Is there any European level act regulating artificial intelligence right now?
Right now, the comprehensive legislation of artificial intelligence, it's so-called Artificial Intelligence Act, which actually has another different long name, the regulation of the European Union establishing the standardized approach to artificial intelligence and so on. But shortly, we call it Artificial Intelligence Act usually. It's this act currently on the stage, not on draft, it's already passed by the European Parliament, but it's not that is not law yet. It's in the stage of bill, and some step or some stage of the legislative process.
Yeah.
It's not
So,
not eventually passed, not eventually law, and it's not into force, of course.
So this is what is called trialogue stage. So now European Parliament, Council of Europe, no, Council of
the Council.
The Council.
Simply the Council.
And European Commission have to agree on the final version of this act. Okay, so right now we are speaking only about the GDPR, since AI Act is not yet a law of the land, right?
No, not yet in law. Is not yet a law and not yet in force. And
Okay.
Speaking about the GDPR, the typical case which is covered by specific rules of the GDPR is Article 22. It's about automated decision making.
Yeah, let me open the article. By the way, we are using the website which is called GDPR text.com. It's a website that is developed by our company. So we use it for training purposes at our courses, but it also allows us to kind of work in multilingual environment that we are working right now by comparing texts in our native language with English. So let's open this article 22. Let's switch to English.
It's worth to be mentioned here that this article was not specially developed for the cases of artificial intelligence. It was developed for the cases of automated individual decision making. And when it was drafted, the artificial intelligence solutions were not so in common and so widely spread as now.
So right now they are trying to fit this article to a new problem, to a new
actually it's
designed for, right?
Actually, it's the first point which usually we encounter with when we are applying some algorithms, including machine learning algorithms or artificial intelligence technology. But it's not all, of course. And can I share my screen?
Yeah, go ahead. Please go ahead.
Thank you.
Share. Let me stop my sharing.
And Norwegian Data Protection Authority made it clear already 5 years ago that actually we can speak about 2 cases of the application of GDPR to the context of artificial intelligence. The first situation is when we use personal data to develop AI solutions, and the second situation is when we use some technology, AI-based technology, to reach some individual decisions. Not only individual decision, when we use personal data to reach some decision about individuals. It's a bit broader than Article 22nd. And in the given example, we have exactly the first situation, which is pointed out by the Norwegian Data Protection Authority, when we use personal data as training data for AI solution development. Why? Why? Some people, especially without a special legal training, may ask a question: why? In such case, we should apply GDPR, apply data protection law. And the key to answer this question is in the definition of the processing of personal data in GDPR. The processing of personal data is defined widely. There is no exhaustive list of the operations which constitute the data processing. Any operation with personal data constitute personal data processing. So use personal data to develop a solution is training data constitute the processing and triggers the application of the GDPR. And the Clearview AI case is the best example which illustrates that we should apply data protection legislation in such cases. And exactly in this example, Clearview AI, this American startup, used personal data to develop a facial recognition solution, and they used photo of they created huge database of pictures of people from open source, mainly from social media, from different social media, and they created database and created algorithm which is able to recognize people by face. And a lot of
Clearview AI is quite straightforward example, because the result of this facial recognition training is actually personal data, so it allows to identify people. But
yes.
What if the author of this question, if the company that is using the chat box for training its AI model does not output personal data per se. So, for instance, this data in the chatbot is used for better diagnosis, but avoids there's going to be no personal information in the output, in the end product, in the model. For instance, I tested recently the model for voice recognition. I'm pretty sure it was trained on YouTube data, on some other data. I'm pretty sure it's not possible without training on the large data set that it's so precise. It's surprisingly precise, but the model itself, I installed it on my server and ran a script. Does not contain any personal information of any people whose voice and speech was used for this purpose. So, yeah.
Actually, there are two sides of this problem. The first one is that, formally speaking, and just based on the exact meaning of the wording of law, not only personal data in output, but personal data as input triggers the application of data protection law. And it's formally speaking, it doesn't matter that the result of the model, the result of the algorithm doesn't include any personal data at all.
Yeah.
We use personal data on the training stage. It means that we process personal data.
Thanks for emphasizing this, because a lot of clients, a lot of people don't really think so, because they say, okay, the output is not personal, so why do we have to comply with the privacy legislation? Or sometimes they claim they don't have IP requirements working for them, because the result product is not IP protected. It's not
Yes,
intellectual
yes. And if we read the decision on the Clearview case of the Commission nationale de l'informatique et de liberté, French Data Protection Authority, we can see the argumentation which they use there, and they clearly emphasized the point that any process of personal data, including use personal data as training data, constitutes personal data processing and therefore application of the GDPR. And so we should apply all data protection principles, such as purpose limitation, first of all, and lawfulness and fairness and transparency. In the given example, maybe we can go back to the scheme.
Okay, let me reshare the picture. So in the given example, let me add this process of machine learning. So as I understood, they have a website, they have a chat bot. This information is entered by data subjects to the chat box here. Then the information goes. Actually, it is already possessed by data controller, by the company. But over here, instead of that, let me show this AI training purpose. So the purpose over here is AI training. And according to the question, the information is also, or maybe primarily, is collected for the health service.
Health service, yes.
Yeah.
But the purpose of the development of this AI solution, it seems like it's linked, and it's in the close connection with their main purpose of processing. Yes, do I understand it correctly?
So they integrated an AI chat model. So start chat actions implies user consent. So this is a question not related right now to the processing. We'll think on that. Then it doesn't say that it's strictly necessary for health service provision. So I believe we can safely assume that there is no interdependency between those purposes. What kind of
I'd say
because they don't apply AI to answer the questions of the patients. They train AI, the model on the questions of the patients. So it's not required. It's not strictly required for health service provision.
So first of all, they are able to provide the patients with the service, with health care without AI. In such a case, it triggers that we should rule out the contract obligation as the legitimate grounds, because the purpose of processing data is not the fulfillment of the contractual obligation. The test which should be applied here is strict. The necessity test is always strict. If we are able to reach some result without this processing, it means that it shouldn't be justified by this purpose.
Yeah, I wrote down two more possible legal grounds. I wrote out public interest, vital interest, and what else?
Legitimate interest, of course.
No. Legitimate interest is in
It's
the scope.
because health data.
Yeah.
Yes.
Yeah.
If it
Okay.
wouldn't have data, it could be.
So let's cross legitimate interest, because the sensitivity of data does not allow, implies that there would not be possible to balance the interests of data subjects against the interests of company. And legitimate interest is always about finding the balance. It's a balancing test, as they call it in the guidelines and GDPR recital. So we are left only with consent, right?
So we have only consent here, but application of consent in the AI training process is problematic. First of all, we should assess the mechanism of giving this consent. Is it really freely given? What consequences would be if the data subject refuses to give the consent?
Yeah.
And if we deprive him from using the service, it's not freely given. Yeah,
so let's return to the question, and it looks like they would like to use this start chat action as a sign of giving consent, which is not freely giving consent, because it's the action has two meanings, and the first and the most important meaning why people press this button, they wanna ask a question, not show you their consent for machine learning training. So it's not you cannot bind these two actions. So there should be a separate tick box without not pre-ticked, right? Where so affirmative action is possible, and full information given to data subjects about this additional purpose of AI training.
And without any impact on the core functionality.
Yeah. So to put it shortly, you cannot use this action as consent action, like affirmative action.
It's not a valid consent in accordance with GDPR, accordance with Article 7.
7, yeah, correct. 7. Yeah. Because the definition of the consent and the requirements, the conditions of the consent listed in the Article 7 of the GDPR, they stipulate that it should be affirmative action, and we should avoid ambiguity. When you connect to things like getting the medical advice and giving consent into one action, then you are ending up with ambiguous situation where the same action potentially could mean two things: giving consent and showing that person needs some health advice.
The next point here is that if we use consent as a legitimate ground for data processing, it means that we should provide the data subjects with the right to withdraw the consent. It may be problematic in the case of artificial intelligence and machine learning because their further data may be aggregated, may be pseudonymized, may be altered in some way, and it's not possible to withdraw some data belonging to a particular user, to a particular individual from the whole data set. It may be problematic technically. And also when we discuss the point of the applicability, I mentioned that there is a second side of the problem, and the second side of the problem that yes, usually we we say that the output of the algorithm, the output of the training data doesn't include personal data. It's just an algorithm of work. But I discussed this issue many times with different data scientists, with different data professionals. And some of them, most experienced and most qualified data scientists, said that in some cases it's possible to infer, to reverse engineer personal data from the output, from the algorithm. It's not, it shouldn't be considered, algorithm shouldn't be considered as personal data itself. But we should make some precautions, some guarantees to avoid and to maybe mitigate this possibility, this risk to reverse engineer personal data which were used during the training process.
Yeah.
And
may I read some comment for one of the participants? For the privacy purposes, I don't read the name of the participant. I don't think that Article 22 automatic decisions has too much in common for general chatbot in place. Yeah, may I answer this question? Yes, general chatbots are not the tool of automated decision making, but when you add AI functionality and some decisions that are taken further after this text input, it becomes relevant. Would you add something to this?
We just mentioned Article 22 because it's usual case which may be linked with the issues of artificial intelligence in nowadays practice, but of course it's not applicable in the present question.
Okay. The second comment: a chatbot is not expected to make a decision with. Okay, this is we already covered. So, what is the correct basis in this question for the processing? Not sure if adding one more box to be ticked out makes it valid consent if the other conditions are not met. Absolutely correct comment. The tick box itself is not all all that you have to do. Along with the consent, collection of the consent, there are some other.
And
rules.
also, as we just discussed, that even if we imply the correct mechanism of obtaining consent, we may be not able to provide the data subject with the right to withdraw the consent from the aggregated data set and the output. So data subject consent is not the ideal legitimate ground for this case. Probably we can resolve this issue by developing some mechanism to anonymize and aggregate data, because in many cases it doesn't mean that some information is linked to some particular individual. For instance, we may need data which have the same characteristics as personal data. For instance, diagnosis and name, but it may be not real name. It may be just artificial name with the same characteristics. For instance, we can replace John Schmidt by Harry Potter. It doesn't matter for the algorithm. And also maybe we can try to develop our system of training in such way, at least to at least masking personal data, maybe just to replace some direct identifiers, but by some maybe constant figures, or maybe some other figures. Yeah, I know that there are many solutions on the market which provide the algorithms, the models to mask personal data or to pseudonymize personal data. And in one of the previous my places of work, we use directly with teams who develop artificial intelligence solutions, and we have some models in place which were trained to find personal data in data sets and to replace direct identifiers with some other figure. Like an example with Harry Potter. It's not real name, but it has the same characteristics as real name. But we have another problem here, that sometimes, for instance, if the figure which we use to replace is not constant and it's invented by the system, it may coincide with the real data. For instance, generated phone number may occasionally coincide with the real phone number of some person. It's also the problem, and but I know that data scientists in big teams, in leading teams in the world, are working on this, and also have some technical solutions to avoid this. And also. It may be the first way, maximum of pseudonymization, maximum and probably maybe anonymization of data.
So I have a tricky question for you. It wasn't asked. And it shouldn't be answered right away. But should we get a separate legal ground for anonymization as a process? So is it it's another purpose? Should we get the legal ground, or like legitimate interest? Probably legitimate interest would be fine with that. We don't need to consent. Data subject doesn't need to consent to anonymization. But the question is, because if you train the model on anonymous data, then this training is outside the scope. But what about the anonymization itself? Because and could we combine those two processes of anonymization and training into one process, and in that case get locked with the same issue? Because if we believe that the anonymization is just the first stage of the training, then the purpose of training is still present, and personal information is still used on this first stage, and then you would need to get consent for the whole process, not just anonymization, but anonymization plus machine learning.
It's a really tricky question, and I think there is no right answer, and there is a strict approach. And if we adopt strict approach, it's actually a blocker to use personal data for this purpose. But business, and especially innovative technological business, should develop the solutions should go further. And I think that I believe in the second more relaxed approach that we
Divide
can use
those two purposes,
yes,
right?
can divide two purposes, yes.
Yeah, it would be great to hear from the supervisory authorities, because I
Of
think
course,
it's
from the court.
yeah, from the court. By the way, are there any cases by European Court, by Court of Justice of European Union to about AI? It's too short period for those legal cases to reach the highest judicial
I'm not
branch.
aware of such cases yet, and I think that probably this question wasn't yet in the focus of the Court of Justice. And also, I didn't hear, especially, I tried to monitor the legal practice and the case law with this topic, but I didn't face yet any decisions which could be useful for the clarification of this point. But probably in the nearest future, they will appear. What else we can say here about this purpose of creation the chatbot? We can try to implement quite a sophisticated legal argumentation why we use personal data to train the algorithm, but also to be it's a so-called compatibility assessment test, or test de compatibility, when we consider two different purposes of data processing, not separately, but in the close connection. The principle of purpose limitation prohibits us from processing personal data for the purpose which is not compatible with the initial purpose. But as Working Party Article 29 said in one of its old opinion, it said that it doesn't mean that it prohibits us from using personal data for the purposes which are compatible with initial purpose. It may be another purpose, but it may be compatible.
So another way would be proof compatibility between the initial purpose of providing
yes, exactly.
The medical advice and the additional purpose of training AI.
And in such a case, we can try to apply here one of their exceptions to process special category of data, which mentioned in the Article 9, for instance, for public interests connecting to public health or something else. But this approach is risky, of course. There are many risks which are included in this approach, and we should make a lot of additional precautions. And even the same compatibility assessment test points out on such precautions. First of all, we can explore the Working Party Article 29 opinion on the purpose limitation principle. It was proved. It was issued before the GDPR, something about 2011 or maybe 2012. It's quite an old opinion. But when the GDPR was passed, its text, particularly paragraph 4, as far as I remember, of Article 6 includes, implied in some indirect way the compatibility assessment test. And about a year ago, I've come across with the excellent French decision, excellent French no decision, excellent French guidance. I want to share my screen. I mean, what I mean. The CNIL is the best in the area of artificial intelligence and cutting-edge technologies. CNIL is the best. They, despite being famous as one of their strongest data protection authorities in Europe, it adopts quite flexible approach in the areas connected with the development of cutting-edge technologies, and they have this excellent document. Ce traitant la réutilisation de données qu'on fait par un responsable de traitement. It's only in French available. It's not translated in English. It's guidance for data processors for reuse personal data for the purposes which may be considered compatible with the initial purposes for which the data controller processes the data, and to authorize the processor to process this data. The CNIL mostly follows the logic of Working Party Article 29, but they also clarify some specific points, especially regarding to the development of AI solutions by data processor, and they offer to take into account several facts, several circumstances to assess the compatibility. First of all, of course, the link between the initial purpose and the further purpose. The second one is the context of processing, which includes their relationship with the data subject, the way how personal data was collected, and the result for the data subject, and so on. And the nature of personal data. It's important for the present question because we have sensitive data, because the data of special category. And also the measures which we implement to protect the data. It seems that it's not about purpose the same or processing the same, but about the measures. But it also affects the eventual conclusion: is the processing of personal data lawful or not? And I strongly recommend to use this tool and to read this guidance in the whole, and to implement it in work, as well as other perfect French instrument, Guide RGPD de l'équipe de développement. Guidance for.
Sorry for interrupting. Did I understand correctly that it's only for data processors? It's not for data controllers, or it is for data?
The first instrument, yes, it's for data processors, but the logic which is involved may be used in other cases.
Okay, understood.
I think we don't have too much time, and we can go maybe to the
let's go further. Let's go further to.
I think we answered the first question.
Yeah. To sum up, you might be able to use consent here, along if it's truly freely given. If it's if you are able to realize data subject rights and
first of all, right to withdraw consent.
Yeah, including the right to withdraw consent. So let's go to the next question.
Sorry for interruption. And to sum up, the first solution is use consent if we are able to implement all data subject rights. The second option is anonymization. And the third option is compatibility assessment and this smart French approach, I'd say.
Okay. Yeah. So let me check the timeline. I don't think that we have much time left.
Yes.
Okay, we have
only one question. Yes.
Yeah, only one question left. So let's discuss it quickly. We wanted to develop an AI-based product. However, we are not fully aware of all potential risks and consequences. Specifically, we are concerned about the risks related to personal data protection. What are the risks? How can they be mitigated? So we basically answered the question about the risks related to the company, like company risks, not data subject risks, about using the wrong legal basis, and about fulfilling the obligations of data minimization and purpose limitation. But maybe since they are just developing AI product, could you say, Denis, what would be necessary for them if AI Act is implemented when this AI product is launched?
My advice here is first of all to conduct data processing impact assessment, data protection impact assessment, because even we are not sure that there is a clear trigger of mandatory DPIA in accordance with GDPR, but we have some doubts about the possible impact. It's better in accordance with our accountability principle to run the DPIA here. And then the result of DPIA just points us the next direction.
I see. So unfortunately, we don't have much time left for the last question, but maybe we'll try to answer in a couple of words. I had a question for you. If a company based in India and with no offices in Europe and Turkey, but targeting their customers in the EU and Turkey by virtue of their service offering, then would such companies be required to appoint an EU or an Turkey representative? Please let me know. Okay, so let's narrow this question to Article 27 of the GDPR, because no you nor me are experts in data privacy in Turkey, so we have.
I can say about Turkey.
Okay, go ahead. Go ahead.
First of all, about Article 27, yes, we can see that in accordance with Article 3, paragraph 2, the GDPR applies, and so on. It's trigger of application of the Article 27. In accordance with Article 27, we should appoint a representative.
Yeah, and Kaloyan Petrov, one of our viewers, who's still with us, thanks for being with us, although we are a bit late. also agrees with your opinion that EU representative is mandatory in this situation. What about Turkey?
For my best knowledge, the requirements of Turkish legislation is quite different at this point, and as far as I remember, there is no the requirement is not the same as in the European Union, but some local person should be appointed. Yes.
Okay.
But
Right.
there are some differences. But it's a topic of separate discussion.
Yeah. Thank you, Denis, for this comprehensive approach to the questions of our viewers. I know that we had a couple more questions on your side that we asked you to collect these questions on your side, but probably it's a topic for another discussion, for maybe a separate dedicated webinar. Let me sum up what we've just learned during the conference and what would be the action plan that we promised to our viewers here. So right now you can see the full picture of today's conference. On the right, yeah, we covered the most interesting aspects of compliance. Please make sure that you follow these steps of this flow chart for every single process separately of other processes, because every purpose might like change in the purpose, or the combination of purposes might change significantly the role, the lawful basis, and as a result of different lawful basis, the data subject rights and other measures. So what we learned. First of all, we learned that at my presentation, you can rewind the video and watch it. I showed the differences and nuances over criteria of identifiability, and there is a hint, there is a tip to businesses is to use the proper contracts with the processors to make the information that that is seems to be pseudonymous. You might use the current case if it's approved, if it goes through the whole line in the European Court of Justice. It might be this information might be considered anonymous. Then we skipped the topics of joint controllership and the role of the processor to the crucial topic of operationalization of the data minimization and purpose limitation principles, and with the help of the magic matrix that we will share with the registered participants. And if you watch this video in the recording, you can still register for the conference, and we will share and send the materials to you. You could teach your teams to assess the purpose limitation purposes and limit the use of personal data. With the advice from the presentation of Louis-Philippe Graton, you learned that it's necessary to find the balance between business interests of startup to save and to cut the costs on the development and implement privacy measures on another side. We heard quite tremendous stories about class actions and fines. Not fines, the suits and expenses that the company face if they work on American market or other in other jurisdictions. With the help of you, Denis, and at the consultation with Christopher Schmidt, we were able to figure out certain advice for the companies that were locked in the situations when they don't have SCCs for their situation. We right now we were discussing the topic of AI, and so far, right, about AI, we have to follow mostly GDPR rules, but be aware that AI Act is coming, and a new set of rules would be needed to be followed. And there was a great session on CIPP and CIPM certification for those of you who just enter the field or consider whether you need some kind of external confirmation of your competencies. So with that in mind, I'm happy to announce that we reached all our purposes for today's conference. We will contact you by sending the presentations and materials about our company within our legitimate interest, of course, since this is a free of charge event. And we, as official IPP training provider, will probably send you the materials about our next upcoming IPP training. And as me as a trainer for DPP Data Privacy Professional course, we will also be included probably in the marketing materials along with the slides of today's presenters. And if you need some advice, if you need to elaborate on your questions that you asked, please don't hesitate to contact us at DPO Europe GmbH. The website is dataprivacyoffice.eu, and we'll be happy to assist you. So thanks a lot. Thanks everyone who is watching this video right now or watching a video in recording. We are very happy with the result of the conference and the audience of the conference. So see you next time, and probably the next time will be actually not quite soon, since we are preparing the conference on the Emirates legislation, on the PDPL and the executive regulations. So pretty sure that within next 3 to 6 months, you'll be hearing from us. So bye-bye, everyone.